6 minutes, we should like to call for an additional application.
Next resolution. I beg to mention item 48, hearing of last item, yes, madam. Some particular difficulty after 2 weeks.
I to mention item number 18 and 19. It is not received. You never need to exempt from- Yes, sir.
I beg to mention item number 34, Lordship. I am referring for respondent number 2, Lordship. Respondent number 2 has recently received notice from the Honorable Court and engaged us, so Lordship, we have not filed Vokalatnama till now and intending to file Vokalatnama. We have taken the consent from the petitioner, Lordship. Yes, Nazneen, maybe Lordship. Lordship, we will file Vokalatnama today, Lordship. SK Dal, Lordship. Dahal. Matter will be listed, Lordship, after 2 weeks, Lordship. Yes, Lordship. Obliged. Obliged. I beg to mention item number 3, make to Lordship. Maybe I don't know. Thank you. There is some personal difficulty. CD is not available for the subsequent application matter. Earlier it was rejected by my and this 23 matter. Before I will take the instruction. Lordship, that is the particular lordship. Very different. School Kerala Carbon Mota, Martin and Community Secretary for UAE. Tennis School of UAE will be quite high during the atmosphere, which will be coming from one police. That is the FIR. My submission is this the sand fiber. We won't go to see just even shortly.
On 5th of June. be reported.
This one. Yes.
This is a 482 daily petition, my lord. In this case, what happened, my lord? An FIR has been filed against the petitioner under section 366, my lord, stating that her daughter has been eloped by the, my lord, petitioner, my lord. Subsequently, what happened, my lord, actual fact of the case is that, my lord, the girl came with the petitioner on her own will, my lord. And thereafter they married, my lord, they have a, my lord, children also. Now the informant also come, my lord, of willing to, my lord, pursue the case, my lord. Your lordship kindly come to the, my lord, FIR. FIR is page Annexer 1, page 15. With due respect, I would like to state today that on 29/12/2020 at about 3:30 afternoon, the above named accused person has forcefully kidnapped took my daughter, namely Ritika Biswas, from the road. She was returning back from home. Dholpur having after receiving her meal during time of Saraswati Puja. So FIR has been registered number 366, my lord. Girl is matter, my lord, because your lordship kindly come to the Annexer 2, my lord, page 21, my lord. That as per my lord, column 8, page 21, my lord. Column 8, my lord. Column 8, my lord, no sexual intercourse took place, my lord. Second, my lord, qualification, ossification case for patent age is above 18 years. Plus minus 2, my lord. Assuming everything I am submitting, I am an authority one of the effects for my license, submit before your lordship, my lord. Lordship kindly come to the affidavit filed by the informant, my lord. I have to give the photocopy and others, my lord. Affidavit has been, my lord, swear by my lord, informant, my lord. He has stated that the lordship kindly come to the para, my lord, 5, my lord. My lord, para 4, para, my lord, 3, my 4, my lord. Then I said my Ritika Biswas subsequently married with Durga Das from 10 as per Hindu rites and custom. Then our wedlock, a girl child named Khushi Das was born. 15/10/2000, they are living in the native village. At the home of the amicable sector, there I am not willing to continue before a period case number source for better future of my daughter as well as my granddaughter. Then your lordship come to affidavit filed to the alleged victim person, my lord. She has stated that on 2 paragraph 229(1), I voluntarily made Durga Das, son of Kusal, the resident, police, Bipure, rescue me, document as Lavithia. Then I went to Durga Das without informing my parents. Thereafter, Father Obidas logged an Ezahar, in charge of Dholpur police subsidiary register as Bipure, Durga Das lived married with each other as a Hindu rite and custom, since we are happily living with a husband. Out of said wedlock, Khushi Das was born on 15th, and presently we are now residing happily. I have no grievance against my husband Durga Das. I am, my lord, relying to judgment of the apex court. Yes, my lord. Not received. My lord. Yes. Yes, but my lord, assuming but not admitting the facts. Now they are, my lord, living happily as a husband and wife, my lord. And there is a judgment of the apex court, my lord. If, my lord, at that time, suppose we kidnap that girl, thereafter this thing has been happened, my lord. Then also, my lord, this affair is liable to be, my lord, revoked, my lord, if amicable is settled. I have two judgment, either I have given to copy, my lord. Whether, I have taken to copy, my lord. Let's kindly go. 2010 SSC, 10. Yes, my lord. Fazli Ghaffar Khan. Not Fazli Ghaffar Khan, my lord. Yes, my lord. I think informant also appear. Yes, my lord. that the appeal faces criminal proceeding on child under section 360 allegation that he kidnapped minor girl. On the basis of first information, police took up the investigation, submitted a final form. A protest petition filed by the complainant. Here, my informant has filed a protest petition. That magistrate treated a complaint to cognizance. The accused moved the High Court under section 480 for quashing the proceeding. The High Court having refused to quash the proceeding, and the present appeal has been filed by the court. An affidavit filed on behalf of the girl has been clearly stating that she is married to the appellant accused. In view of such affidavit, the court has issued notice pursuant to which the state entered appearance, but the complainant did not make any appearance. In the light of the affidavit, the girl admitting marriage between her and the appellant, statement made injurious and uncounseled appealing for the state was born. A appellant that a child was born. We think it interested to quash the criminal proceeding. We therefore allow the appeal and direct the criminal proceeding to be quashed. Next, my lord. Mafatla. 2022-6 SSC. There are 6 minors. It was father said almost 15 years has been by living happily married and also blessed with a boy 27 to 2014. His father stated that in absence of never victimized, abducted, kidnapped, but on her own volition, never bears the home on account of unexpected disturbing circumstances created by her. It is also stated that abducted was 17 years. My lord?
Yes,
My lord.
understated.
Yes, my lord.
Who stated?
I am reading from the earlier. There are 4, my lord. It is the abductee Seema Parwa filed a petition the section 4 before the Rajasthan High Court, which was registered as the law. Yes, yes, sir. Yes, correct, correct. Yes, sir. Yes, sir. Correct.
Yes.
A penalty.
What do you say?
My lord, I support.
Because about what?
Both the parties have mutually understand. So I don't want to continue this case.
Very important.
Yes, my lord. So it will hamper my daughter's family because she have a child.
Let us see you on Monday.
Yes, sir.
In this, we try to put it. Mr. Sorry, your name?
A penalty.
The concept of something is that
They are the interview. Interview. Just one. My pleasure, Lordship. Lordship's application under section 482 share Lordship for quashing criminal proceeding PRC case number 147/4/22 arising out from Olgasia PSK number 987/92. Lordship is offense under section 366A/34. Lordship, first of all, I would like to put for the FIR. Lordship, FIR is phase 11. Lordship. The informant, the informant respectfully begs to state that on 13/10/2018 at about 11 a.m., while my sister, namely Afroza Khatun, was coming back to the home from the Saraswara Higher Secondary School, with the association of other accused number 1 kidnapped my sister by motorbike and kept her in unknown place. This is the allegation of FIR. Lordship. Now, charge sheet Lordship is page 17. Lordship. I'd like to read charge sheet, relevant portion. Lordship. Brief fact of the case is that complainant, namely Minarul Islam, son of Abu Bakr Siddiq, village Khili, post office Moza Titabani PS, Kolkata district, Borpeta, Assam, lodged and detailed FIR, and on the basis of said FIR investigated the case. During the investigation, visited the place of occurrence and prepared a sketch map. Recorded the statement of witnesses, recovered the victim girl and medical examined her in FAHMCH, Fakhruddin Ali Ahmed Medical College and Hospital, Borpeta, and recorded her statement under section 164 CRPC before the Honorable Court of Borpeta. And as per order of the court, victim girl was given to the custody of her father. Collected the medical report of victim girl from the statement of witnesses and 164 statement of court against the accused person, namely Sahib Khan, son of Parvat Khan, village Saraswara Reserve, post office Sikri, PS Kalgasia, district Borpeta, Assam, found of sufficient evidence of offense under section 366 IPC. Lordship. The accused person appeared with a clearest bail from the court. So after interrogation as per order of the court, he was allowed to go on bail. Lordship. Therefore, the submitted charge sheet against the under the aforesaid sections to commence trial against the accused person. In the other hand, against the FIR name accused number 1 Lal Khan, 2 Parvat Khan, 3 Habibur Rahman, not found sufficient evidences so paid for release them from the case. Along with the charge sheet enclosed one sketch map, the place of occurrence, medical report, Zamin Nama, witnesses mentioned in the court, column number 6 will prove the case. This is the charge sheet. Lordship, now, Lordship, I have collected certified copy of 164 statement of the victim girl. Lordship, that was annexed with my petition. Lordship, 164 statement is Lordship page 24. Lordship. Lordship, may I read? My name and addresses are corrected as stated above. Since 2 years from today, I fall in love with Sahib Khan. On 13/10/2018, I eloped with him and stayed in a house of one relative. On that day, physical relationship was done between us. Thereafter, a person from my home came and taken back me to the home. Then I staying at home. Page number 24, Lordship, type 40. Vernacular is 25. Lordship. 1/2/11/18, again I eloped with him. Lordship. And one night stayed in his maternal uncle's home. On that day also we did physical relationship.
After that, he again kept me back. Sahib Khan not forcefully kidnapped me. This is the statement of victim lordship, recorded under section 164 CR. Lordship, medical report also, victim girl, she denied to examine herself medically, lordship. At the time of occurrence, lordship, victim girl was aged, lordship, 17 years, 4 months, some days, lordship, 2 days. Lordship, after the occurrence, victim and accused person got married, and they are till they continuing their conjugal life peacefully. And out of their woodland, lordship, one girl child has been born. And in the meantime, lordship, informant of this case, lordship, brother of the victim girl, came forward and he has executed a notary affidavit, lordship. That was also annexed with my petition, lordship. Case 32, lordship, notary affidavit. Yes, brother of the victim girl, lordship. Yes, yes, lordship. And lordship, please see the case 32, lordship. Informant executed a notary affidavit, wherein he stated that he has not objection if this honorable court. Yes, lordship. Yes, lordship. In the meantime, lordship, further proceeding of this case may be stayed, lordship.
Should we call for SCR lordship?
On 64 statement, it's not supported the case of the prosecution, lordship. Yeah, एक ही आजाद, lordship. एक ही आजाद. PRC case number, lordship. 1474 of the 20 years. Case number 1474. Yes. 987. That's the issue number 1 is the use of AI. Issue number 2. Victim girl, yes. And the child informed to do that. And the referee to the statement role that issue number 164 which is includes this nature 4.4 that the stone question there you go. And was in relation to the branch and possible and is categorically stated that available the investigation the instruction to do 135 and the other 68 yes, yes, one is everybody stated that there's no objection. Everybody stated that So I'm paying for the further proceeding stage.
At this relevant point, the victim was a minor.
Lordship,
And our consent
Sure,
before the eyes of law.
Those- Though she was though she was a minor, but she was it's about 17 and 4 months. Lordship. So he has a sufficient capacity to give her consent.
To pass the order first. Then we'll argue. The scale of this. Case reports and exactly here in this.
Most of them.
They are property land lottery. And combining the lot and entering fully lottery. And the respondent number opposite but not in 5 other lottery. That is coming to the petition of lottery. Because they have submitted petition before the additional district magistrate lottery. Festival lottery. And on this basis lottery, the district magistrate send it for inquiry lottery. And thereafter lottery finally, there is possibly order page 18 lottery. The district magistrate pass this order lottery. Mary lottery. Page 18. Case record put up today in my file. In the complete petition, they are trying to enumerate Palasama and the photocopy of land gates, given 5 by 3 grams of and again, Steve Nasi, and 5 others, all the residents of Part the first party is manner. Also, periods the petition, habitat with the manner. It appears from the police report that they are arising in land dispute between both the parties regarding taking possession of the schedule mentioned below. The second party entered in the land of first party and tried to take the land of first party, and the second party members are very serious in matter. As such, there is every possibility of breach of peace and public utility in the law. As per complaint petition, the first party stated that the below mentioned schedule land number 1 is the partial property of the father of first party number 1. He has been enjoying the same land from his father's lifetime, and the schedule land 2 is paternal property of first party number 2, and she has been enjoying the same land by right of inheritance. First party also stated the second party members always try to occupy the below mentioned schedule and forcefully and unlawfully and effectively disposes the first party from the scheduled land mentioned below. And the first party tried to prevent the second party from doing illegal activity. The second party attends them in this because there is a fear of violence and breach peace and security because both the parties yes, second party and proceeding under section 7 was from lordship and the lordship, the first paragraph, last paragraph, 19 lordship, The second, yeah, Lordship, resting in the second party, members in the entering the schedule. They have given the second party, members appear before the court and file application proposed to why they should not be asked to execute bond of rupees 200,000 each. They have given chance to appear before the court. Lordship, they did not come before the court, Lordship. They filed a revision petition, Lordship, before the session. And they repaid 32, Lordship. The session court, Lordship, admitted this, the Lordship, by this order, admitted this revision, Lordship, and they suspend the operation of the state order, Lordship. Lordship, where my humble submission is there, Lordship. In this regard, Lordship, the order passed by the additional legislative interlocutory order, Lordship. And the, as per section 33 and 397, 2, Lordship, the session proclaims the power, Lordship. Lordship, 397. Lordship. 397, calling for records to exercise powers of division. The High Court or any session judge may call for and examine the record of any proceedings before any criminal court, speed within or in local jurisdiction for the purpose of verifying itself or himself as to the corrective ability of or priority of any finding, sentence or order recorded or passed, and as to the regularity of any proceedings of such individual court, and may, when calling for such record, direct that the execution of any sentence or order be suspended. And if the accused is in confinement, that he be released on bail or on his own bond pending the examination of the record. Lordship, 2, Lordship. The powers of revision conferred by subsection 1 shall not be exercised in relation to any interlocutory order passed in any appeal, inquiry, trial, or other proceeding. Lordship, by this, Lordship, the
At least his lordship call for the case, scan copy of the website. Petition court to establish.
and the proceeding of the revision, Lordship, would state, and Mr. Amendment. four offices in that area, maybe. But I need to. But maybe four of them. Maybe reduce. Very important. Very this. View of the body. Congregates internally or interlocking the people that of the past and transform it. And thousand very good. These those who keep it the constellation of the that's partly the it's important that you use some of this that is reports and at least state those reports and copy that report and then you have case report.
Yes.
If you sort of how it's sort of pollution comes. It is a bit of steps of this. Well, revision, it is, I always say, immediate revision can stay. This is so good. Other.
So the application for quashing of an FIR. FIR, the lordship finds at page 31. But before that, if I may quickly trace the background. The accused and the informant, they were partners of a partnership firm. Now that partnership firm is known as the Premier Tea Industries. It runs tea factories at Golaghat. Basically, it was a family partnership, as in two families have gotten together. One a Hindu undivided family. My mother and my cousin were also partners. But the firm ran into losses. Since I was one of the we were managing the firm at the relevant point of time. They came up with allegations that we did not make, we sort of mismanaged the fund, which is why it had gone into losses. And accordingly, several proceedings were initiated. One such proceeding was a proceeding under Section 9 of the Arbitration Act, since the partnership agreement contained an arbitration clause. In those proceedings, consent orders have been passed among the parties. And secondly, there's also a revenue proceeding pending as regards mutation of a particular land, which we say is our mother's property, and they claim it to be the firm's property. Additionally, now they want to pursue with this FIR, which your lordship finds at page 31. Now it's a longish FIR, my lord, very craftily drafted, but essence of it, your lordship will find it is a commercial dispute concerning the affairs of the firm. Now,
the allegation is that you have illegally converted
the firm's property to you, and for that, my lord, they allege that I carried out a mutation. Now that mutation originally was in the name of my mother, and therefore the legal heirs were mutated. My lord. Be that as it may, my lord, that mutation order has already been taken care of by the revenue authorities, which your lordship finds at page 57.
These respondents, who are the respondents? They are your relatives.
They're not.
Respondent number 2.
Respondent number 2 is the other family. My lord. Two families which had got into a partnership, one a Hindu undivided family and
Which is the equal.
the informant.
Yes.
Now, my lord, finds the section 9 order at page 55.
Yes.
This is the final order passed in the arbitration proceeding. Petitioners are present, respondents are also represented. Today is fixed for hearing on the petition filed under section 9 of the arbitration in page 55. In extra 5. Fourth paragraph onwards, learned counsel agreed. No, this is an application under section 9 for an interim relief. Learned counsel for the appearing on behalf of the respondents have verbally submitted that as per order dated 15/12/22 passed by this court, no any alienation of property has taken place till date. He has further submitted that no any alienation of property will be taken place in future without prior permission from the court. Learned counsels appearing for both the parties have further submitted that they will appoint an arbitrator in respect of their grievance. Considering the facts and circumstances on record, and also considering the submissions of the learned counsels for both the sides, the respondents are directed not to alienate the property till constitution of the arbitral tribunal. Further, both the parties are directed to take appropriate steps for constitution of arbitral tribunal to settle their grievance within a period of 90 days. Now, on the following page, your lordship finds the revenue order, order passed by the ADC. So, in the FIR, my lord, the allegations are threefold. Number one, they say that as per the audit, there has been some misappropriation of funds. Now, that I would say is a matter to be decided in a proceeding for rendition of accounts of the firm. Second grievance was we are trying to alienate the property. There's already a standing order under section 9. Third grievance was that we had effected mutation of the sons of the late deceased partner, and that mutation has also been corrected by the ADC, which your lordship finds at page 57. Now, Lord, over and above this, Lord, if they are allowed to prosecute me criminally, Lord, otherwise it's a pure commercial dispute, Lord.
What are the sections?
Sections alleged have been 409, which is of course not applicable to me because they are also alleging collusion with the revenue authority. Additionally, there's 420, 120B, and 106. No, my lord, few statements have been recorded, but no charge sheet has been filed. My lord, there again, my lord, perhaps is referring to Niharika, my lord. My lord, Niharika also at paragraph 60, my lord, has given some exception, carved out an exception of sorts in respect of civil disputes, my lord. Now, my lord, if I may just rely on two judgments, my lord, one is subsequent to Niharika and the other is the Indian Oil Corporation's matter, where the ground reality was taken note of, that now there's a tendency because they think civil remedies would be time consuming and therefore they want to additionally investigation. It is possible that true, my lord, but once they file a charge sheet, my lord, they'll steal a march and that is how they are going to exert pressure. Now, first, if your lordship takes up that 2006 judgment, yes. Paragraph 13, if your lordship takes up, 13. And while on the issue, it is necessary to take notice of a growing tendency in business circles to convert purely civil disputes into criminal cases. This is obviously on account of a prevalent impression that civil law remedies are time consuming and do not adequately protect the interests of the lender's creditor. Such a tendency is seen in several family disputes also, leading into irretrievable breakdown of marriages families. There's also an impression that if a person could somehow be entangled in a criminal prosecution, there's a likelihood of an imminent settlement. Any effort to settle civil disputes and claims which do not involve any criminal offense by applying pressure through criminal prosecution should be deprecated and discouraged.
Hold now. Why say proceeding,
Because that is how they're going to exert pressure. Once a charge sheet is filed, I'll be subjected to a trial. If they file the charge sheet, it becomes infractuous. And perhaps the Niharika, that paragraph, I can just refer to that. Niharika, para 60, you can watch it. Takes now. In a given case, after the parameters are laid down, in a given case, there may be allegations of abuse of process of law by converting a civil dispute into a criminal dispute, only with a view to pressurize the accused. Similarly, in a given case, the complaint itself on the face of it can be said to be barred by law. The allegations in the FIR may not at all disclose the commission of offence. In such cases, and in exceptional cases with circumspection, the High Court may stay the further investigation. Now, the same was the case with Vijay Kumar. Malad, I'll just pray for a state till their appearance, Malad, because your lordship will appreciate it's a sort of a forum hunting which was also taken note of in the other judgment, Malad, where multiple proceedings are initiated and additionally a criminal charge is sort of like inflicted, so that I buckle under pressure and there are multiple proceedings. There is already a Section 9 order. They have both the parties have undertaken to go for an arbitration. There is a culminated, concluded revenue proceedings. Now, allegation. If your lordship takes out the FIR, I'll show what is the allegation basically. They did not turn up to sort of pay the bank dues. Therefore, I paid the bank dues out of my pocket. How can that be criminal breach of trust? Even the yes, 8. It is further pertinent to mention that Vinod Kumar Agarwala has wrongfully converted the firm's movable assets by selling the inventory of the partnership firm to third parties without the knowledge and consent of the other partners, and has misappropriated funds received from the sale of such movable assets of the firm to third parties for his own use. On 29/22, Vinod Kumar Agarwal and Jiten Brithani deposited a large sum of money of 2.45 lakhs into the loan account of the firm without the knowledge and consent of the complainants in order to illegally obtain original title deeds deposited with the bank in collusion with the officers of the bank. Now, my lord, my land is encumbered. They do not come forward with payment of the dues of the firm. I shoulder the liability of the firm and I make payment to the bank. And they're saying I have committed a fraud or a criminal breach of trust. I'm at a loss. I have shelled out money and have shouldered the dues of the firm. And now the allegation is reversed. And whatever movables have been sold or inventory manipulated, these are matters which the arbitrator will take note of when eventually a settlement of accounts or a rendition is given effect to. Now, to prosecute me under 420, and then second ground is I mutated the name. The land was mutated in the names of the sons of the deceased partner. Now, the land admittedly was in the name of my mother. Now they want to say it got converted into the firm's property. That charge sheet immediately they file it. So therefore, your lordship will examine after the appearance. Just till the returnable date, because otherwise prima facie your lordship has seen that it is otherwise a commercial dispute among partners of a firm.
Yes. And
Yes, Lordship. Otherwise, it's a commercial dispute between individual groups. We already have entered into a partnership deal, Lordship, regarding their business. We can also the notice should go. And in the Lordship, call for the case that in respect of the Lagan case, they have 344 of the 22. Because it is at the investigation stage.
yes. And it's,
PT.
and
PT.
PDF. And Mr. Anton, the council again for the commissioner. There's this.
Responding to. Partners, my lord. Not all the petitioners, my lord. One and petition number 1 and 2 and the respondent number 2.
Petitioner, the respondent.
And their mother,
Respondent, who
mother of all the petitioners.
Partnership people.
Team has.
See, partnership people in the They don't really get mother of the consequences. They be the nice so they mother of the necessary for relevance where initiated or transfer or updating the data that immediates.
No, it
By the respondent to respondent to. The respondent to.
page 55.
already you can be through the that's that is the parties not really needs the property details. Without property needs and property without prior permission. Point an arbitration. With respect to the demands. And feel. But it would be unconstitutionally arbitrary having. Responded with I. The council. Right, the matter was approved with us, gave this one to. I, the time. The simple, there is allocated to this.
Page 31.
Very right, so the allegation would be, it is the. Petitioners. And the.
Yes,
And the.
yes, their name, the body. The first paragraph,
But usually petitioner number 1 and 2
1 and 2, but not even the others were named.
is only.
Yes. On page 31, they've named all of them.
Again, the petition. The council to petitioner. So this, the dispute may be between the respondents are purely excluded. There is a group of business. Then. The allegation. The allegation of the internal acts in a related allegation does not have a behavior of the reading of the third one. In a given case, where the dispute is in file, or there is a signature to file, allowing any of the parties or any criminal acts of petitioner. It is intent to expect her pressure on the parties who on the open side. Not the is on the open side will not be considered. And the
ADC owner, ADC has cancelled the mutation and directed issuance of notice. So,
Industries.
yes, ADC Golaghat. Great, RKG 38 of 20.
RTC is for RTC 38. The substance. There was no vision for the issue that's made. The addition of the activities that by loading the space, by loading the app, because what they're doing is exerted enough pressure and the relative force for an unloaded gate. This is the order that you can put the state something that is that the mapping of the
Yes, 44 of it, 2022.
Produce basic. We are already going to the
Lord will say no coercive steps in. Lord, no coercive steps.
giving you some other way about it.
Lord,
We are already going for. What more can you seek for?
nonetheless, Lord, the image.
7th of June.
In the basic fix. No more steps. The review of the. That is also into basic. So, we have to say
150.
Deep build.
Left digital.
Yes.
Left digital. That is the application alleging under section 346, second minute. Affairs is 11 minute. Made it. It is respectfully submitted there on 24/3/2023 Friday at about 12:30 at noon when I was about to for my humanamas about mentioned persons came along with arms because of inimical relation and
And no motion. It was earlier actual
Actual.
motion that.
Petitioner and the accused person there radar minor. And there is a boundary wall disputed minor between the minor. And the petitioner attacked with a broom minor.
Then when they attack with the bomb, my lord, apprehension, my lord. The equipment. No, accused number one, brother of the accused number one and accused number two is the Nekum. Nekum.
Is something that we inform is some people probably should be very grateful. We are in one way from the based on the
Twentieth of June. Two zero.
Right.
After is eight matter. In this case, the petitioner is not named in that fact.
Any other critical regarding this legal
No, my,
legal
I don't know. I have no knowledge. Already in this case, my lord, main equity already arrested and subsequent on bail.
very legal.
No, already arrested and released on bail, my lord. Those are involved, my lord. Yes, as per
They already have it.
yes, other
They quoted by the which one?
court below, my lord.
Course.
Gaड़ी driver of the vehicle and one real position of the
Very high court order.
No, my report bill.
No, there is a reference of the high court order.
Fine.
What I'm saying.
I have, I have no knowledge.
Have you not read the order? The knowledge will come from reading the order. Really. Read the order, there is a reference there. And Mr. Ray. There is a reference from the high court order.
Yes,
Now you have the knowledge.
yes. Or is there a
Yes, it is. And then the- Submitted. We can speak the environment, but that is what it was. Because it comes
Twenty-two six. Zero six. Lost.
So come to affair matter, I like to address one thing matter. He has matter employee in his family matter. Accordingly, my lord, his name has been deleted from the beneficiary list. And accordingly, my lord, bank concerned authority has asked the bank to refund the amount. He made a complaint, my lord, he knows it, my lord. Annexure 1 is the affair, my lord, and annexure 2 is my lord. Who are you? My lord, petitioner number 1 is the in charge secretary, my lord, chairman. Number 2 is the BDO, my lord. Number 3 is the ground sevok, and next one is the my lord, coordinator. He has done, my lord, his father is having, my lord, government job. Accordingly, my lord, we have cancelled, my lord, and by letter, my lord, lordship, kindly have a look at page, my lord, 37, my lord. Way back in the December itself, my lord. May I read, my lord, small paragraph. Reference to the above factor, I am here to inform you that amount of 35,000 has been wrongly credited to our hand on the account of Mizadur Rahman being account number so and so. Hence, you are hereby requested to refund the amount of 32,500 so and so to the nodal officer with a intimation to the transaction ID and details of the undersigned so and so man. And it has been written on 17 December man. He made a complaint to the authority, my lord, that annexure 2, my lord. That is, he wrote written a letter on January 13 at page 17, my lord. Then, my lord, he written, my lord, he knows it, my lord. Operative part, second paragraph, my lord, it is mentioned here that as per the direction of the secretary, so and so, his employee, after examining my documents, entered into an agreement, so and so, for construction of the, everything was done well. On 7/5/12, an amount was sanctioned for construction of the house on 17/12/22. Big complaint was submitted in the bank and hold my sanction amount, so and so 32. Then, my lord, to overcome this, my lord, he lost an affair, that annexure 1. Annexure 1, my lord, at page 12, my lord. That is the affair, my lord. Just to overcome that, my lord, and Lok Sabha has, Gau Sabha has cancelled his name, my lord, because his father is having government job. Affair is at page 12, my lord. He has named out, my lord, all 4 persons. Respectively, I beg to state that I am the beneficiary of the house issued with the name of restitution number so and so. Forfeited so as to the directions of the chairman, Kaupachar, after examining all the documents, his employees all entered into an agreement for contractual construction of the everything is going well as per the rule. On 70th, the central bank so and so branch deposited amount so and so. Here, the first instrument, the part of the first. Affair was lost, my lord, it is in the recently, my lord, May. On 5/5, my lord. The interior protection be given, my lord. One is the chairman, my lord, in charge secretary. 2 is the video. 3 is the GRS, my lord, gram. 3 is the GRS, and 4th is GPC. Member. GRS is, my lord, gram Rozgar Seva, and GPC is, my lord, gram Panchayat coordinator.
There are three of my petition I have stated, madam. Five. What you will see Barnacular at 816. And type copy is also there. Please, English also there. What does that is? Both are informed by the examiner of my. This one is the time. House. Registration number. The one word, other one that. Amount of money from this important. In terms of the sincere, village, this direction of the chief chair. Spending how long. 10,000. Which was the responsibility. The amount of the people how long ago. And I took the house, the family. And we there. Also, the company was also made the video. And wasn't very good, but it was another company. So, force and there is some persons from people administration. Amount the accounts.
Second of June. Also.
After it split 9 miles. Land dispute melody is long back melody at 10 miles, one proceeding melody, 107 is indicated like this person by the author. This is the clause and yes, madam. Here is melody. 10 petitioners, madam. Who is already arrested, madam. Yes, madam. One Aman and madam Mazid. One Mazid. Mazru. Serial number 1 and 9. Aman and Mazid. Process are also. What are regarding land dispute, my yes, yes, and he yes, 40 minutes hour. Yes, best 40 minutes. Here is also my now not accepted. Same table. A petitioner said, my lord, a lot of are earlier by, but something. This is the registered or under section, my lord, 143, 147, 148, and 325. Up to 60, my lord.
What should I call the case stories in my school?
One kind of zoom.
Silence.
Irony. Like.
higher. One user yes.
Informant. Informant and
Is something that these members has. Enter into the land of the. Prevent them from. Because some of the time,
Okay. 2016. Lodge.
In this methodology product, senior counsel is as something with the given notion. That time.
Monday.
We will the next.
Make the document. On 438 application month. FIR at page 8 month. Actually, there is a family dispute regarding distribution of property mother. The mother has got this case against this one son minor. Mother is in the party of another son minor. The family dispute mother. And they have settled the matter also, and an affidavit has also been sold to the defendant mother.
Your occasion lordship statement of the victim was called for. Yes, question. That perhaps not received, like I did, because the sorting.
AB 170.
Yes.
Yeah.
This matter.
Yes, Lordship is possible. Give us one date, Lordship.
Yes, but my lord, I had this with others on. This. So we only want to. Really, house. I persons photos on the fence.
Is the mother of the petitioner number one and mother-in-law of the petitioner number two.
The mother of the one. And that is violated laws and yes, so. Another brother.
Another person.
Is
Like me.
yes.
Apply.
Yes.
28.
On the last day, in two aspects. They were to reply. They have raised objection regarding alternative remedy and that there was a query. Preliminary. But it was hard. What has happened in 1994? I joined services. I was terminated without any DP. Yes.
And your the library
Yes.
is
And
My lord, immediately, my lord, there is no DPU or initiated against the my lord petition, my lord. But my argument is, two arguments, my lord. One is that, my lord, penalty was imposed upon the petitioner under section 7 of the Assam Service Disciplinary Appeal Rules, my lord. In the same statute, my lord, section 50. There is the same statute, my lord. There is a provision under section 15, my lord, to appeal against the orders
imposing penalties, my lord. If I may read section 50, ma'am.
And you square to initiate proceedings before any
Appeal special matter. Penalty imposed under section 7. Rule 7. Ma'am. Page number 440. This page, madam. Rule 15, my lord, say a government servant may appeal against an order imposing upon him any of the penalties specified in Rule 7 to the appellate authority specified in his behalf in the schedule. It says that a government servant may appeal against an order imposing upon him any of the penalties specified in Rule 7. And my lord, this petitioner penalty has been imposed upon the petitioner under Rule 7, sub-rule 7, my lord. It is in page 432, dismissal from service, which shall ordinarily be a disqualification for shall not be disqualification for future employment. In that regard, my lord, I submit one judgment, my lord. It says that
Yes.
it's a judgment, my lord. Para 6, my lord. Six onwards, my lord. It says that, my lord, if the statute provides a right to appeal against appeal, my lord, then a petitioner has to avail that remedy first before approaching the High Court, my lord. But there is also, my lord, question is same, my lord. The statute provided appeal. There is a provision for appeal in the statute itself, my lord. So the court says that when there is a provision of appeal in the statute itself, then the petitioner has to avail that remedy first before approaching before the High Court, my lord. In the same in this case also, my lord, this act, there's a rules, my lord, provide there is a provision for appeal against the penalty imposed under Rules 7, my lord. So my argument is, my humble submission is that, my lord, before approaching before this honorable court, the petitioner must have approached the authority for under Rules 15, my lord.
Yes.
In view of that, my lord, the petitioner shall be directed to approach the authority, my lord, file an appeal.
What is the rule? What does the rule say?
Rule 15, my lord. one file.
Yes.
Appeal against order imposing penalties. The government servant may appeal against an order imposing upon him any of the penalties specified in Rule 7 to the appellate authority specified in this behalf in the schedule. There shall be no appeal against the order of the appellate tribunal. This says that if a government servant has been punished under Rule 7 manner, then he has a remedy to approach the authority by way of appeal under Rule 15 manner. And in this case, the petitioner has been punished under Rule 7, sub-rule 7 manner. He has been dismissed from his service due to
I think we take it up in the second half.
Yes, sir.
The very matter.
Just one, small. It is a question of alternative remedy which is raised.
In the second half.
Okay.
Let us make it in the thing. Because there is only the very matter.
330 manner.
It's a transfer petition, my lord. I am playing from my lord from Kohima to my lord Dimapur, my lord. The lordship is turned to page 35, the charge sheet, my lord. My lord, I have narrated my grounds, my lord. The lordship may kindly see, my lord, page 5, my lord. Page 5 onwards, my lord. Page 5, my lord, ground number B, my lord. More particularly, ground number E and F, my lord. More interestingly, my lord, although I have not taken the ground, my lord. Well, there, my lord, I was on bail, my lord, and I have to take a local bailer, my lord. And each bailer, my lord, after 3-4 months, my lord, they withdraw, my lord. Again, I have to take a fresh bailer, my lord. That's one of the problem, my lord. And moreover, my lord, one thing, my lord, lordship, kindly see, my lord, page 35, my lord. Page 35. Lordship, see the my lord, charges, allegations against the accused person, my lord. Page 35, my lord. The charges are, my lord, section under section 419, 1, 2, and 3, my lord. 420 and 466. Page number 35, my lord. 35. My lord, the charges, allegation against the accused person. 1, 2, 3, my lord. 1 is 419 IPC, 2 is 420 IPC, and 3 is 466 IPC. Here, my lord, against 3 arrested accused persons, namely Mohammed Rashid Chaudhary so-and-so, Milonchuk. Number 2, Rahul Sen. I am appearing on behalf of number 3, Jina Raja Alam, for the offense of forgery of certificates and documents of an NBSE, Nagaland Post State Education, Kohima, Nagaland. It's a case of forgery of certificates and documents. Now your lordship may turn to page 32 for a once, my lord. 32, my lord. First paragraph, my lord. All the exhibit, but this is the charge sheet, my lord. All the exhibit items have been submitted to CFSL Kamruk Assam for forensic examination and expert opinion, which would be submitted to the learned court as evidence as and when received, my lord. Till date, my lord, that FSL report is not before the court, my lord, trial court. So how this the court can, my lord, proceed under this section, my lord, 466? My only prayer, my lord, I am not praying for to transfer the case to Assam, my lord, only to Dimapur, my lord, as because I am a resident of Gwalpara, my lord. I'm not praying to transfer to other state, my lord. Maybe in Nagaland, my lord, from Kohima to Dimapur. That much.
May I, your lordship, one submission. Since we do not, lordship, that is what like I would like to clarify. Since the informant is also this thing, Nagaland board or government official, so the government advocate Nagaland has been asked to appeal. And for the this thing PP also, since we do not have a Nagaland, we do not have a PP appointment here. So in both the cases, government Nagaland, government advocate appeals. And it would not be appropriate if today, like my other colleague is out of station. Your lordship, we kindly take up this matter after 1 week. She's gone out of station. It would not be appropriate if I stand for both the parties. We do not have a PP appointment. Only government advocates. Usually they do not come. All these times, like I'm saying, it's always the government advocates who has been appearing.
So far the bails are concerned, my lord, PP is required, but so far it's transfer petition, my lord, the government advocate can appear. My lord, on the last
State represented by PP.
yes, that's true, my lord. That's true.
Even everyone, tribal or criminal.
Yes, your lordship.
My lord, can it be a stay of that proceeding, my lord?
Lordship, then too it would be difficult because
Because as you say, the reports are not there.
Yeah. That's what, my lord.
Who's taking the proceedings?
In the next day, my lord.
Why is it not being considered here?
My lord, earlier, my lord, first of all, my lord, they want to appear on behalf of respondent number 2. Then they sought time for filing affidavit. And accordingly, they filed affidavit on behalf of respondent number 2. And affidavit
Reason means they.
instead, my lord, because he is also sick, my lord, that instruction I. It's a date. Yes, my lord, next. My lord.
lordship, since I filed the affidavit in this case, so I'll be appearing for the respondent number 2, government advocate.
Some is that we take it as the state council represent the state of Nagaland, we are all responding party. So that should be. Yeah. So going on. It's continuing. Before we score.
My lord, before the court of judicial magistrate, first class Kohima, Nagaland.
It's the steel. Doesn't come to
If possible on 2, my lord, next Friday.
No.
Then 6. So the only problem is that, my lord, the bailer out there, my lord, they are threatening us, my lord. We'll withdraw it.
There were nine.
Mal.
There were nine.
Mal.
Six about it.
Keep your flags. I'm online.
Eight years old. My lord, as on date, 93 days in custody now. As of
Charge it, not submitted, the idea.
This something. The middle county. So there is still very few even in the international data. What you see is not the predicted. Because I the COVID one is needed to go. The investigation is bad. Signing the very important. That there is no relation that sustain against the news. This was. And all for it. 17 like that. Yeah. As on dates, the commission that have been paid. Custody forward. How many days?
my lord, 93 days. 2 days, 92 days.
There is a will be. Okay.
CGM Hajo, my lord. Judicial magistrate, first class Hajo. Yes, my lord, page 15 is. Judicial magistrate, first class Hajo. Hajo, yes.
Additionally, I think for the investigation, I think the investigation. Yes.
Like.
Yes.
Yes, the ID receipt.
Yes.
The petitioner was registered on 9/4/2023. As of today, 46 days, madam. 46 days. The petitioner was arrested and he was forwarded to the court of CGM. And the fraudulent report is disclosed. My statement is already been recorded. And I also disclosed the name of some persons as per fraudulent report disclosed. So, I am also confessed the before the IU.
Mobile phone. Say, basic standard. While you put it useful, you go about standing thing.
I will, my lord, undertaking that I will not, I will help the IU. I'll help the IU to name the other this person. I already disclosed the name of some person. So I have a lot of details of the land of the and my statement is recorded. You also can see my
Your statement, your technical reasons, I agree. These are the right that you are committed. There is a guarantee that you will not to be your ideal type.
actually he has
Someone being released on pay.
and he disclosed that he confessed all the matter because of person. Because of person.
You admitted.
It is here, not there. But police. Oh, not of details by
But you disclose anything safer inside. You disclose the name of your police.
I think it is the same. I will help the IO to name those persons. So I am not there.
He has given the name of some personal expense that is there in the diary. But he is also on this, yes. He is a veteran, my lord, that's why police arrest.
It is there, yes. But so my is concern, I have mentioned, but due to this structure.
Repeatedly better you stay in the. You won't believe. You'll be more helpful by staying inside. Several. You want me something? 46 days, that is all right, my lord, but he is a veteran, my lord, of this type of matter or goals since side. Any other cases? Police says that, my lord, he is a veteran one. His number not mentioned, his number not mentioned. And no, that's disclosed, my lord. They normally do that. He has given the name of some persons, my lord. It may, my lord, presume that, my lord, he has some link with those persons. Otherwise, how could he know the name of those persons?
But it is mentioned in the record that I have
Disclose.
earlier. But
Not then we see on the list. My lord, is very application.
my lord,
You cooperate,
I will cooperate.
you cooperate. That the. Please say that you have cooperated and nothing more is there, so we need to after that.
I will help the police to name the other persons. I will commit that. I will help the police.
There will be change in the.
No, my lord. But I am not involved, my lord, in that. I am not involved. That is why I disclose the name persons, that area. I am living in Khatikal area, my lord.
No. Not, what do you say? Not a good place for me,
My lord.
not a good place.
But only thing is I am more,
That is, people don't know the difference.
I am living in Khatikal area. And accident token is different area. So I disclose the name of some person.
How do you know?
Maybe this is why
How do you know that this person?
Maybe.
Committed. Because you are part of the same gang.
Actually, he said that due to police torture, I could not tolerate the torture. No, anyway, my lord, by considering the length of detention, I will help the police. And if they found anything wrong, they will take me up to them.
You will be waiting for them to report.
I will personally go there. I will personally.
It will be easier not to lose. Not to lose. You do not want to lose.
And I'm not lost in but
My lord, he is right of involved in such type of matters.
Right, we are not going to. Please, please. Let us keep it moving. We very easy to be.
next to get 6. Kiran,
This test was fixed. Trial is going on in this test was fixed. And on last of the 10 copy was called for. And the accused behind the bar for 1 year, 10 months more. And all the vital witnesses, informant as well as the victim section has been recorded and one in PWC was also recorded. In the section 6, Fox record. Right. And then before it is that Hamad. I have to enhance the PW1, PW2 and PW3. The certificate
copy is not been received. Although this court has ordered it to invite the name for social. Reports. I think that will be. Special also cases of 37 28 and 30. Specifically one. Please. After. Receive this conference. Mr. Papa. This was and.
register maybe directly to send one reminder acted.
For this campus.
After 1 week.
We are saying that this after receipt of this campus.
The Paris case 9 there is 3 accused person also, and the accused number 3 is equal also. And the FIR. May I read?
Yes.
Is the accused number 1 has been after my daughter, namely so and so by making false promise to marry her since last 3 months. At present, the accused number 3 by making comprehensive if the accused number 1 in an unambiguous and has been saying that he has been missing. Only allegation that against the petitioner lordship, he has been saved the accused number 1 in an unambiguous.
Yes. Medical everything there, my lord. But the 164 statement of the victim, my lord, says that, my lord, this person helped, my lord, the main accused, my lord. Main accused in another person, my lord.
Nazim. Nazim. I don't know how to skip so far. There is 3 months.
Amjad Shah. Amjad Shah.
This state nation very both by informant. Sound and say, Person being this person is number one person. They have the value in Myanmar, I mean. You can take so. And program. Every. And they do conspiracy they do the investigation. Initiated by the then from they're known to each other. They had a relationship. After this knowledge, the relationship will establish. Then, the same is for one. Maybe when you order fast things, which is better. In case any as when the bill they receive that statement, it was made under 6164. Made under 61, that's probably by the as really personal. Even safe enough to not embody the evidence. The reason of the environment, the reason of the is that will be see which is the Divisional 376 see that we make it safe to make the development decision. And this is going to be. There should be a section. There should be. There should be. It's going to be the. For the.
It is in not some of them.
For the investigation, this is the mission of the investigation. For the on the jurisdiction of the specific order.
For 39 verification. The is 9. This can be that petitioner and the victim almost as a minor, and they had love affairs, and the victim related with the petitioner. And this affair is 9. Is 9. Maybe the amount sufficient is there. One so one baby given. She's very mother informed my daughter in so and so. There is 14 years has been missing from our house. Actually, my daughter has been staying at the house of so as family relation. Thereafter, the baby is tasked everywhere and came to learn there upon people is something has been escaped and kept at the video herself recovered the boy and the girl with the head of police. Thereafter, the matter was informed to the Hatigam police station, and on the very day in the morning, the Hatigam police brought the boy and girl from the Shuksa police station. Thereafter, I came to know that I filed the exam because the Hatigam police station. Notice that on the very next day, the thing has been recovered and her statement has been included under section before she
She herself has a lot of lordship with this boy lordship, but she is 15 years only.
investigation. Invested for the 18 who are
Regarding her, where she decided,
I know some, refer to some lady.
plus her statement is also there. And her father's statement is also there. Her father said also that I haven't taken my class. Father said also as she was residing to Pali Rompi. Other statement lordship, she paid from their home and she began to decide with this baby, baby numbers. And
Really important.
baby.
Other. Subsequently, father is informed and he filed the FIR.
But why is it so really important? Very big.
Then we will inform the father of the victim. As the victim has been residing at the house of his relative.
Yes, what is it?
Window she has admitted lordship that she herself, she on her own will she has eloped with him lordship, but she is minor lordship and her in minor she is only 15 years lordship.
So we are not hearing the key for saying that, considering whether it's custody is further necessary. So,
In this is almost completed, lordship, the victim has been recovered and her statement has been recorded and the victim stated then no physical relation has been. Empty. Yes.
should say,
Aha.
Yes, law.
This. What is it? There's many things. I think, so I four night. That is when we meet. And since then we will. Then comes in. I think. Right. Or my, portions of the feet. So we have seen that on 3004 from 9 AM on 18 April. Well, from her that means use of the Pange home people into the looking at the so it is that it is the environment total the same at the house of the government and regulation. See very big with that the original meaning we will start. The speeds. This was something that we received that we get a babies, they go, it will go and the that was there from the station. And then be while you go from the on the station. First, we see the fire. This one, very. The difference in type of see. It's very important. Which of there is a very statement, 64 years. The CB means that in our statement made on the 164 that we see it had stated that she had committed. She had her own. She on her own and the division of people of Islam was known to be taken over for 1.5 years, 1.5 years. People Islam into their religion. Also, the stated that she would not want to go back to her Jerusalem. Yes. use the word. Statement and significant. Forwarding letter. The medical officer. The statement of there's not really a appointed descriptions. I mean, it is really not. No one's negotiating. Only giving the one from the party. There is a say. It's okay to be that. Investigation of this as so animals. That included having on these professional investigation and expression of one of the jurisdiction of the investigation. We don't have to be one. CDA number. Data. We
PW for 2 weeks, madam, and then that we can also get report about it.
Okay. Yes, Mr. Gogoi. That's Mr. H.R. Chaudhary, that is City Council. Assisted by Ms. Eka. For the petitioners, Mr. B.D. Gogoi, DPP for the state. This criminal petition is filed by the petitioner. One petitioner. One petitioner.
Yes, one week.
So
He
it's
was called down my law, subsequently case was filed and cognizance taken against the other person.
aggrieved by the
Page my law 31, 32 and 34.
orders passed by the Court of CJ in PRC case number 58 of 2022. By the orders dated 11/3/2022, 12/4/2022, and 6/5/2022. Post of Learned Counsel for the petitioner submits that the petitioner was shown as an absconder in the charge sheet which was filed by the IU in connection with which particular case?
Yes. Now to this resource case, PRC case number 7.
No, earlier. Dhubri case, Dhubri PS
Yes.
was filed in connection with Dhubri PS case number so. Also, then a counsel for the petitioner submits that the petitioner was submits that the court of CJM issued proclamation and attachment, PNA, as well as an NBWA for securing the presence of the petitioner. Also, the other senior counsel submits that the petitioner was never an absconder and he was always available. However, for reasons beyond his comprehension, he was shown to be an absconder in the charge sheet file. That apart, the impugned orders which were passed by the Learned Court of CJM issuing, directing issuance of proclamation and attachment is contrary to the provisions of CRPC as laid down under section
Section 82,
82.
83.
82 and 83. Full stop. Being agreed, the present criminal petition has been filed. Where Mr. V.B. Gogoi, Learned APP submits that the petitioner should go and appear before the court and contest the matter. Also, having heard the learned counsels for the parties and upon due perusal of the pleadings on record, it is seen that essentially the court of CJM had passed these orders to secure the presence of the petitioner who was shown to be an absconder. Also, in the charge sheet file, absconder in the charge sheet file. Also,
But in the meantime, committed of the arrest of other 2 persons committed to such by order dated 6/5.
in the meantime, the
Page 35.
matter has been committed to the court of session judge. Insofar as the other 2 accused persons are concerned by the order dated 6/5.
Yes, page 35 also. Page 35 top 5.
6/5.
Upon revision of the case record.
Also, this court is of the view that the issues pertaining to the submissions of the learned senior counsel in respect of the issuance of PNA by the court of CJM, being contrary to the provisions of
Section
82 and 83, can be urged before the state court upon filing proper application seeking the recall of by filing appropriate applications. Full stop. When is the next day?
Next statement is actually, in fact, here it has given 9/5 idea. This one
It is
actually not provide.
this
That is
court
the
upon
regarding other 2 equipment.
this
In my
court,
case, it is 5.
this court upon consideration of the entire matter feels that this petition can be disposed of with a direction to the petitioner to appear before the competent court, namely court of CJM,
Commander CGM.
and file necessary applications seeking recall of the orders passed by the court for the recall for recall of the issuance of for recall of the orders passed for issuance of PNA. Also, accordingly, the petitioner is directed to appear before the court of CJM within a period of 15 days from today. Also, if the petitioner appears before the court of CJM as directed by this court within a period of 15 days from today, the NBWA issued
against the petitioner shall be recorded. Full stop. Till the time the petitioner appears before the court of CGM Dhuri, and up to a maximum of 15 days from today, the NBWA issue shall remain stay. The criminal petition is accordingly disposed of in terms of the above directions. Petitioner will be at liberty to file necessary applications for recall of other orders passed regarding issuance of proclamation and attachment, as well as for bail. The criminal petition,
Period, my lord, interim period.
we are extending for 15 days. It will stay. Accordingly, the criminal petition stands disposed of in terms of the above.
Obliged.
As you let me go.
Bail hearing period items 18 and 19.
NBWA stayed for 15 days from the day. Will be able. Yes, Mr. Muni,
Case diary was also, the case may not.
not received.
Not.
Why? Some other date,
Close it.
some other date for case diary? Yes or no?
Yes, my lord, case diary will be required.
Required, yes, yes.
I just wanted because two ladies are there working with the basket 18, one is with a 3-year infant child and another one 5-month pregnant. And the matter relates to purely a civil dispute, civil proceeding is going on, I don't see informally. And it's from Washington.
At the request of Mr. P.V. Gogoi and deputy, the matter is deferred for another 2 weeks. Not 2 weeks, 1 day, 1 week.
Yes, so next week, Lordship, because our infant child is there.
Matter is deferred to, when can you get it? Tell me.
First of June.
1st of June. 1st of June.
Yes.
Enabling him to call for the case diary as directed by this court again. So Mr. S. Muni, and it comes into the petitioner, appears for the petitioner, and the council appears for the petitioner. List on 1st of June. Proceed.
Yes.
Both the cases,
Yes, yes. Much obliged, Your Lordship. Much obliged.
both the cases coming out, arising out of the same police station case.
Much obliged.
Item 52.
Yes, yes.
Under that application,
Some additional affidavit, yes.
Starting off with the additional affidavit. I would like to just read the order whereby my name was detected.
Your name was?
Ajiz of. Lordship, may kindly see the last page, Lordship,
Oh,
of the bail application, Lordship. The page number 30 starts. Lordship, in the middle, peruse the case record. On perusal of the case record, it is seen that the accused person was absent after outbreak of COVID-19 pandemic. The accused persons were appearing prior to COVID-19 pandemic of making appearance when the court may resume. Now, Lordship would now like to see the additional affidavit, Lordship. In the additional affidavit, I have enclosed everything, the entire order sheet, Lordship. Page number 40 start. Now, 18/7/2020, the court was not there, Lordship. 18/11/2020, court was not there, Lordship. Page number 41. 24/2/2021, accused is absent with steps, Lordship. The advocate appeared, Lordship. Now, again, on 21/5/2021, again, court is not there. Then also, 11/10/2021, court is not there, Lordship, but accused has appeared with the, to the council, Lordship. Page number 41. Now,
where do you say that? From where?
page number 41.
How do you say accused Accused is absent without step.
No, which step, Lordship?
Where?
Petition number 20.
24-2. 24-2 is absent without step.
No, which step? The petition. number
Absent
2.
with step, yes, okay.
The advocate appeared.
Then 21-5, not there.
The court is not there. Now again on 11/10/2021, the advocate appeared.
Hmm.
Now in all probability, that was the last day the court advocate appeared. And the advocate did not tell me the date. So Lordship, the next date was fixed on 11/2/2022. So that order may be seen, the case number 44. Accused is absent without step. On 11/2/2022, this is the first time I have appeared without the step.
Hmm.
Issue NPWA against the accused, fixing so as the word. Now, Lordship, may I just refer to the section 81 of the
Now,
CRPC.
first tell us, when were you taken into custody?
I was taken to custody, Lordship, in the month of May, Lordship.
By which order? Is
25.
there an order?
Lordship, in page number 30, Lordship,
Huh?
page number 30.
30.
That is the last order which Lordship has heard some time ago.
Yes.
Now 20, that I have read till the COVID-19 and stopped making effect in the court regime. Lordship has found it, Lordship.
Hmm.
I have also considered the argument made by the learned counsel for the accused, who have stated that since the allegation against the accused person is under bailable section, the accused persons are entitled to bail. However, upon consideration of the argument, I would like to reflect that in a case where allegations are made in bailable section, if the accused person violates the conditions of bail, making regular entry in section, then the bail will be rejected, especially when there are chances that the accused will abscond. The perusal of the case paper shows that the instant case is fit for evidence state and is an old pending case as well. And considering the stage of the case and the possibility that the accused person may abscond will unnecessarily cause delay in the instant case, I am disinclined to allow the bail application. Now, Lordship, can this be done, Lordship? In my humble submission, this cannot be done. So, Lordship, I kindly see section 81, Lordship.
Hmm.
I have been appearing in between the pandemic also. The magistrate did not consider my appearance fully.
CRPC. Yes, 81. 81,
81, Lordship.
yes.
Procedure when the magistrate before whom such person is arrested is brought also. After execution of the warrant, Lordship, this is the section.
Hmm.
The executive magistrate or the district superintendent of police or commissioner of police tell if the person arrested appears to be a person intended by the court which issues the warrant, direct his removal in custody to such court, provided that if the offence is available, such person is ready and willing to give bail to the satisfaction of the magistrate, district superintendent or commissioner, or a direction has been enclosed under section 71 of the warrant, and such person is ready and willing to give security required by such direction, the magistrate, district magistrate or commissioner shall make such bail, shall Lordship, or seek security as the case may be, and forward the bond to the court before issued. Now the magistrate do not have any power to reject the bail application, Lordship. The word used is shall, Lordship. Even assuming I have not appeared in court, Lordship, I am not an absconder. How did magistrate assume that I am an absconder? Is there a report which says I am an absconder? Is there a charge sheet which says I am an absconder? Is there a finding of a court that I am an absconder? The magistrate cannot assume that I am an absconder because I did not appear. In fact, the fact is that my advocate did not appear in the court.
Have you filed a complaint?
My lord. No, I have not filed that. I have not done. My lord. Even if I have not filed also, Lordship, I am not. It is not that I am disappointed to pay, Lordship. And this is an offense of mere offense of 304 lordship, and I'm rested driving lordship.
Yes, when were you taken into custody?
On 25 4 lordship.
Where does one find it?
Lordship is a very difficult itself. That page number 28.
28.
Page number 28, annexure number 5 of the bail application.
Hmm.
Case record put up today. Accused Aziz Haq is produced before the court on arrest on the strength of NPWA issued in connection with the instant case. Since the accused Chanan copy of NPWA and medical report, the accused was made aware of his legal rights and he was stated that he has the means to engage the lawyer of his choice to represent him. The accused person appeared physically fit. Bail application number so and so filed by the learned counsel on behalf of the accused Azizul Haq is being not pressed. One perusal of the case record is seen that on these dates, the accused remained absent without state for which NPWA has been issued against him.
Why is your bail petition not pressed?
But because this court was not there, also this was not a court. In charge, this is the only in charge court, so we had to file in bail application before the original court, which had issued the NPWA.
Which is the court?
That is in page number 30, Lordship. This is the court of JMFC Hado.
That is also in charge JMFC, earlier court.
Yes, sir. So in charge he was there, but he did not enter in the bail application.
Yes. Was there any order for calling for case diary or anything like that? No.
And there was called for.
Scan copy was called for, my lord, so far that is not received.
So, madam, but without the CD, this is the, I have already enclosed of the orders, Lordship. 35 copy of the orders, Lordship.
I think scan copy is coming. You want to satisfy yourself, go through.
He was arrested on the strength of my lord NVWA.
Hmm.
If your lordship satisfied, then my lord, with some conditions, my lord,
Yes.
face bail and with some conditions. In next, my lord, each and every day he should present before the court, my lord.
Yes, ma'am.
Heard Mr. P. Dekal, Learned Counsel for the petitioner, Mr. P. B. Gugoi, Learned Deputy for the state. Yeah, this bail petition has been filed with the petitioner seeking bail as he was arrested on 25/4/22, as he was arrested in connection with, what is that case number?
Lordship, sir. Here case number 44 of it 2018.
Some charge sheet has also been filed.
This is the state of trial, Lordship. This is the evidence state.
Hmm.
We have appeared, Lordship, in the court. We have been granted bail and then advocate appeared and he is conducting.
What is the number of the case?
Here case number 44 of it 2018.
Is there no PRC number?
This is registered as general registered case, Lordship. Here case, Lordship.
In the connection with GR case number 44 of 2018. Also. Learned Counsel for the petitioner submits that the petitioner had earlier appeared before the court. However, because of the COVID pandemic situation, there was a default on his part as well as on the part of his counsel. And pursuant thereto, NBWA was issued and he was arrested, taken to judicial custody. Since then, he was arrested on 25/4/2023. And since then, he has been in custody also. This court, by the earlier order dated 4/5/2023, called for the scan copies of the case records from the competent court, i.e. Court of Judicial JMFC Kamrup Hajo, Oslo. The materials available before this court have been carefully perused, and counsels have been heard. This court is of the view that the petitioner perusal of the orders which are enclosed to the bail petition as well as those available in the scan copy as called for reveals that the petitioner on earlier dates had appeared before the competent courts. However, on some dates, and more particularly during the COVID pandemic situation, he had failed to appear before the competent board, and his counsel also did not take any steps. Full stop. As such, the NBWA was issued by the court, and on a subsequent date when he had appeared, he was taken into judicial custody. Full stop. Having heard the learned counsels for the parties and upon the perusal of the materials available on record, including the scan copies which have been called for, this court is of the view that the petitioner can be granted bail subject to furnishing a bail bond of rupees 15,000 with one local security of like amount to the satisfaction of JMFC Hajo Kamrup. Will it be JMFC or CM?
Yes.
JMFC. Also, the petitioner will continue to appear before the competent court on each and every date. Unless specific orders are passed by the competent court, giving him liberty from appearing on such dates. Full stop. Petitioner will not move out of the jurisdiction of the Hazo of the competent court without. So he is a resident of Durham. He's a resident of Durham. Also, if any of the conditions are violated, the competent court will be at liberty to cancel the bail granted by this court. Bail is allowed and disposed of.
Item 53.
Thank you, sir. Okay, for Karina Nepalese. Not for which can popular Richard.
Trial is going on. How many witnesses?
164 witnesses, more than 100 is completed. And
When were you arrested?
When arrested?
When were you arrested?
30/11/2021. 543.
What are the allegations here?
It was a mostly inching case.
Uh,
7 numbers of petitioner before your honorable court.
Facts are against you. The facts are against you. Do you want to place any judgment in support of your case?
Yeah,
Ask my lord, let this scan copy come, my lord, because more than 100,
I think it has come.
I see.
Uh,
Morning
There-
they says that,
They're available for you.
oh, morning they say that not received. Then we have to go through it, madam.
All right.
I am reported for fail because charge sheet already filed. Witnesses already examined.
Show us some authority. Mere submission will not do. You must base your submission on the basis of the provisions of the act or some authorities. How much time would you require?
My lord,
Let learned
sometime.
Learned APP, Mr. So-and-so, seeks some time to complete his instructions in the matter. And also peruse the scanned copies of the CD which has been received by the registry of the court. He therefore prays for 2 weeks,
2 weeks, my lord, yes.
2 weeks time.
Meantime,
MS M. Das, the counsel appearing as a legal aid counsel. Legal aid counsel appears for the petitioner. Let the matter be listed again on 15th,
yes.
15 June.
Daily list, bail hearing, AB item 20.
Yes,
My lord, FI's case, my lord. 23.
diary not received. Submitted by the learned APP that the CDS call for has not been received. Mr. what is
Sorry,
it?
the statute submitted, the statute submitted,
Oh. Charge sheet submitted.
statute submitted, yes.
It is on thinking, my lord.
It is submitted by the learned APP, the charge sheet by the charge sheet number
232/23,
232/23 dated
31/3/23.
31/3/23 has been submitted before the competent court. Mr.
Hey, how are you?
A. Hawari, learned counsel appears for the petitioner and submits that petitioner has been granted interim bail. Full stop accordingly. This AV petition is closed, enabling the petitioner to appear before the competent court and apply for bail. The benefit of the interim order dated 26/9/2022 is extended for a further period of 15 days, enabling the petitioner to appear before the competent court and apply for relocation. AV petition is disposed.
21.
21 also statute submitted.
Yes, charge sheet submitted by the charge sheet number
Statute number 66/23,
66/23 dated
29/3/23.
29/3/23. Same order, the benefit of interim bail granted by this court by the order dated 19/12/22 shall be extended for a period of 15 days from today, enabling the petitioner to appear before the competent court and file appropriate bail application. AV petition stands disposed of. Terms of the above.
23.
That's it. Here, my lord, diary is up to 4/12/22 only. So after that diary,
Mr. P.P. Gogoi, Leonard APP submits that up to date case diary is to be called for accordingly prays for some time. Mr. S.M. Abdullah appears for the petitioner, who submits that the petitioner has been granted interim bail.
no interim.
Oh, no interim. Oh, what are the allegations?
76.
Everything is there.
So accordingly, let the matter be listed again on 15 June. 15 June proceeding.
It can be legally started, but no interim.
13th,
Yes.
13 June, okay.
24.
Earlier CD came, my lord, but injury report and medical report. Today also that injury report is not received, my lord. My lord, although the case, my lord, registered under section 376, it is not case of 376, my lord, from the FIR matters. My lord, the FIR is page 12, my lord. The informant is a lady, my lord, having her husband and mother of 2 children, my lord, age 28 years. She herself stated that she came from the house of the accused, in the shop of the accused, and also she went with the accused. And my lord, age 20, my lord, and see, And my lord, several occasions, my lord, who prohibited my lord, nobody prohibited her to like my lord, she was from my initial stage, my lord. My lord, in the time of filing bail petition, my lord, certain document was not with me, my lord. So my lord, later on, file affidavit, my lord. These documents are there, my lord.
Affidavit,
My lord, yes.
I don't see any affidavit.
Yes, my lord, can you see the total is her husband name is there. But my lord, in FIR, he my lord avoided the name, the writing name of her husband.
Have you filed any affidavit?
Yes, sir.
It is not here.
My lord, I filed, my lord. On 4/5/23.
It is not here. It is submitted by the learned counsel for the petitioner, Mr. S. Chauhan, that an additional affidavit has been filed on 4/5/2023, enclosing certain documents. However, case records do not contain any such additional affidavit filed. Also, the registry is directed to trace out the additional affidavit stated to have been filed and connect it to the case records by the next date fixed. Meanwhile, the learned APP is also granted further time to call for the medical report. Medical report also. The CD has been received and the same is to be retained to the next date. List on.
There is no interim is there.
When can you get it, Mr. Gowai?
Yes, Dologam, my lord,
9/6.
9/6.
List on 9/6.
25.
25.
Yes,
8 legal.
CD received.
Here, my lord,
Hmm.
we had lost an FIR first, we received initially, madam, 31, more than 31% my lord, bird injury. Then, my lord, we were hospitalized.
We means
Here, two CDs were called for, one CD received.
That is correct, madam, that is what called.
by order dated 1/3/2023. Case diaries of Dulejan PS case number 03 of 2023 and 22 of 2023 was called for. Learned APP, Mr. Kaushik, submits that CD in respect of
Duration PS case 3/23.
Dulejan PS case of 3/23 has been received. However, the CD of Dulejan PS case 2022 of 23 has not been received. He prays for further time. Mr. Abdullah submits that the petitioner is on interim bail. Is he on interim? Interim bail. Therefore, let the matter be listed again. On 19th July. Proceeding.
Okay.
26.
Yes. At the request of the learned APP, matter is deferred for at the learned APP prays for further time to call for the CD. Mr. D. Gowai, learned counsel appeals for the petitioner who submits that the petitioner is on interim bail. Accordingly, this matter again on 19 July, enabling the learned APP to call for the CD.
27.
Interim order to continue.
27 also civil losses.
Same order. List on 21st July.
It is not an interim.
Yes, interim will be continued.
28.
Wait, please, a minute. Here, the petitioner is an interim matter. He appeared, statement has been recorded matter.
Yes.
Here, up to the city will be required.
Leonard, APP, Mr. R. Kaushik submits that up to date CD will be necessary and therefore he plays for further time. Mr. S.M. Abdullah, Leonard, counsel appearing for the petitioner submits the petitioner then is on interim bail and therefore the same may be extended till the next date fixed. Accordingly, list this matter again on 21st July, enabling the APP to call for the updated CD. Interim bail granted early will continue.
29. It is a city of this. Lots of already 3 days was of performance skill of 2 days.
What are the allegations against you?
Illegal mail, seminar 3 to 6 months.
Hmm?
And lots of totally out of the land is put between parties.
No serious allegations against you. So, call for the CD, get the CD. How much time do you require along with the injury report? CD along with the injury report, we call for. List on 9 June. Mr. What is your name? A.K. Das, Learned Council appears for the petition. List on 9 June.
30 short date maybe.
It is a short date, shortest possible date. Yes.
And then 30.
See, charge sheet file.
No.
No,
Senior.
none appears list next week. CD, it is submitted, CD call for has been received. The same be retained in the next days. Give a date. Let it be on 9th of June.
Interim is there.
Interim will continue.
31.
May I please, Your Lordship? My lord, under CD is not here, Lordship. Lordship, may I pray for interim relief? Your Lordship,
Let us see the FI.
FIR at page 10, Lordship. Lordship, the allegation is that, Lordship, on the earliest date of incident at night around 10:30 o'clock, Lordship, while the victim going to one of the relative, Lordship, house, the petitioners, Lordship, taken him to their house and tied them, Lord. This is the allegation and beating him, Lord. But at 10:30 night, Lordship, this is not visible. Actually, the fact is that, Lordship, on that date, Lordship, at around 12 o'clock, Lordship, he tried to, Lordship, enter into the house of the, Lordship, petitioner's cousin, Lordship. Wherein, Lordship, petitioner's, Lordship, cousin brother was not there, Lordship, and only wife and his little children was there.
This ideal order is for calling for CD along with injury report. So let us,
Lordship, but no injury at all, Lordship. Kindly, Lordship.
we don't know the allegations are there, therefore the injury report.
Yes, Lordship.
There are serious allegations.
Lordship's allegation at 10:30, actually, Lordship.
Why? What is so peculiar about 10:30 at night?
At night, 10:30 Lordship, this is not actually fact. 10:30 because casual visit, who Lordship will casually visit Lordship at 10:30?
We do.
Whether it is.
The allegation is not casually visiting, the allegation is the intent to kill him.
This
That is the allegation.
But he thereafter fled from the place of incident.
Let us wait for the CDE along with the injury report. Mr. APP, when can you get it from Kachar? Which police station? Sonai.
Can you be on 15th Lordship, no interview is there, but on 9th Lordship. 9 will be early.
12th. Let it be on 12th.
All right.
CD along with injury report, we call for this matter again on 12th June. Mr. Your name please?
Finish more.
NH Bormi appears for the petitioner.
All right.
Item number 30, Lordship, I said, under colitis scheme.
We have fixed it next week, come next week, or some date we have given. 9th, it's fixed on that.
32.
And if I will find case number 9, here in this case, Lordship, the five numbers of petitions.
CD?
CD receipt.
But my name is in the serially five Lordship. And first Lordship, the was tracking that Lordship, the petitioner 1, 3 and 4. And there is the allegation level against them in the FIR itself, Lordship. But my name is only my name is inserted in the FIR. But the FIR name petition number 1 is my elder brother. And otherwise, Lordship, I have nothing any involvement at all in the contents of the FIR itself is very much clear. And the case is registered in the year of 2021, Lordship. And since the police never tried to visit my house, never tried to arrest me, Lordship, and never visited my house. But suddenly, Lordship, 3 days ago, Lordship, and the one police officer went to my house, Lord, in connection with this case. And so, my Lord, all the accused were arrested and they were released on bail. But my involvement is nothing, Lord. Let's humble clear. The FIR itself is very much clear. There is not a single word whispered against me. May I read the FIR, Lord? FIR, please.
Read.
It is respectfully submission of the informant is that the accused number 1, 2, 3 and 4 are women traffickers and wicked type of people. The above named accused number 1 taking advantage of absence of my husband in my house called me over mobile phone on 17/1/2021 at about 11 p.m. And offered me a job at Shop Factory situated at Guwahati. And the accused number 1 took me to the house of the accused number 3, where I stayed here for 2 days. At that time, the accused number 2, 3 kept me in a house situated at the Rangapatha for 1 night. Thereafter, the accused person number 2 and 3, on the pretext of engaging me at a soap factory at Guwahati, took me to Delhi through a train. After that, asked me to sit in a counter and offered me tea and snacks and sold me to somebody else at ₹60,000. Thereafter, they took me in the 4th floor of the building and asked me to engage in prostitution. When I refused, then they assaulted me. Thereafter, I pretended that I will kill myself by jumping from the 4th floor and he raised hue and cry. And then the accused person brought me to a counter on 25/2/2021. Later on, I called my husband's mobile number so and asked me to come. And thereafter, they boarded me a train at 11/2/2021 at night at about 11 p.m. And somehow I returned back to my home. And so for allegation, Lordship, that's not against me, all the 1, 2, 3. And actually, Lordship, I was completely unaware about this incident. And while the victim returned to our place, and because he is the same place, Lordship, and he
made complaint to the present petitioner and the elder brother of the affair named case number 1. But and he told the lady that she could not give any justice that because and they are all living separately and that there is such type of he could not be able to do. That is the graduation from the petitioner. Otherwise, not be that fine. And I do not know what this should be.
Because he has not named him, 161 is different.
And she is a lady and I think Lordship and the mother of the three children Lordship. And there is staying at the Dimapur and quarrel took place with the husband of the informant and they deciding at the government with her parents. And if there is anything what the present petitioner Lordship and you know
The 164, 161 does not tell. Any medical? Mr. F. Hawk, Learned Counsel for the petitioner, Mr. Dara Kaushik Leonard. The PP appearing for the state. The PP petition is filed by the petitioner. So and so. Who has filed this petition apprehending arrest in connection with Lowry Act PS case number 89 of 2021 under section so and so so and so. Also. Learned Counsel for the petitioner submits that in a FIR 19/2/2021 was lodged by the informant. One Wahida Begum. Full stop in the state FIR. 5 persons were shown as accused and the petitioner was named as accused number 5. In the state FIR, it was alleged that the petitioner, that the accused person number 1 taking advantage of the absence of her husband from home offered a job at a soap factory situated in Guwahati. Also, the accused number 1 thereafter took the informant to a house of the accused number 3, where she stayed for about 2 days. And thereafter, the accused number 2 and 3 kept her in a house situated in Rongapata for 1 night. Thereafter, the accused number 2 and 3 thereafter, on the pretext of engaging her in soap factory at Guwahati, took her to Delhi through a train. Also. in Delhi, she was taken to a building where she was forced to engage in prostitution. So when she refused, she was assaulted. And thereafter, when she threatened that she will kill herself by jumping from the 4th floor and raised a lot of hue and cry, the accused persons brought her to a counter on 25/2/2021. Full stop. Thereafter, she called her husband on a mobile phone and asked him to come. Subsequently, she returned home. Full stop. This court by the earlier order dated 12/5/2023 had called for the case diary. Full stop. The case diary is called for is being presented before the court by the learned APP. The learned APP submits that the case diary upon perusal of the case diary, it is seen that the victim informant had recorded her statements under section 164 CRPC. There she has implicated the accused person named, accused number 1 named in the FIR. Also, there are no incriminating materials seen against the present petition. Also, the medical examination was refused by the informant with proper endorsement. Also, from the statements of the various witnesses recorded in the case diary, no specific materials are seen. Against the present petitioner at this stage of the investigation. Considering the materials available, by considering the submissions made by the learned counsels for the parties and upon the perusal of the case diary as presented. So this court, this court is of the view that the prayer for anticipatory bail is prayed for by the petitioner can be granted also accordingly. Petitioner, in the event of his arrest in connection with so-and-so case, shall be released on furnishing a bail bond of rupees 30,000 with 1 local security of like amount to the satisfaction of the arresting authority. The petitioner will appear before the IO within 10 days from today. We will not attempt to hamper or tamper any evidence. They shall not attempt to influence or intimidate any person connected with the case. And it shall not move out of the jurisdiction of the Lowry PS without written permission of the IO. If any of the conditions are found to be violated, the petitioner shall be, the IO will be at liberty to pay for cancellation of the bail granted. Also, AV petition is accordingly allowed and disposed of. The case diary returned.
33.
The engagement is under section 3 why between two groups?
Here already started submitted.
That is submitted. So you appear before. As it is, I think we have rejected earlier bail.
Regarding that triple murder case.
Triple murder. One from my lord informant, 2 informant side and 1 my lord on the
Learned APP, Mr. R. Kaushik submits that charge sheet in the meantime has been submitted in this matter by the charge sheet number
41,
41 of 2023,
only 41, dated 16/5/23.
dated 16/5/2023. Also, accordingly, this AV petition is closed. The first of petitioner is at liberty to appear before the competent board before whom the charge sheet has been filed and pray for regular bail. Mr.
Yes, yeah.
S.A. Ahmed, learned counsel, appears for the petitioner. AP petition is, in terms of the above, AP petition is closed.
Supplementary list, bail hearing AB, item 54.
Fifty-four.
Second bail,
Second year. Dr. Point out of your worship text in your worship. This case, Madam Kazi, is the petitioner. And the Kazi is saying the end of Kazi, mother is saying my daughter has not been married. And headmaster says she is reading children in the school. However,
Here, Lordship, one thing, special act is there, madam. I think, it should go to appropriate bench, madam.
which bench?
The court number 9, madam.
any bar is there on what side?
No, circular is there.
এইটোতো ইয়াতে আছে দেখাইলো কথা পাতিলো there is a finding here. More than 7 years. Special bench for what?
My lord, there are 3 type of criminal code. One up to 7 years conviction, then more than 7 years conviction, others are special act, my lord. Those are NDPS, my lord, child marriage act, my lord, like that.
This is pursuant to the registry's endorsement. You verify. We'll verify.
This was point of the last day or 2 years.
Huh?
It was point of the other day also.
Okay.
Point of what, I think there is no bar, my lord.
No. It was pointed out saying that it is a second bail application.
I was not, but I used to be old, my lord.
Here it is mentioned that more than 7 years, my lord. That is, this court is more than 7 years, my lord. But special section, I do not know, my lord. Earlier one notification was there, my lord, special.
I do not know.
Yes. Roster also that is shown.
Whatever comes, we'll hear. Yes.
We have nothing to say, but as I know, my
It is
lord,
pursuant to an endorsement, so they have given a proper endorsement. Yes, what to do?
All your lord, kindly to the FIR, my lord, page.
CD has come.
yes.
Page 12. Page 12. Dedication.
This is AB or BA?
It is everywhere.
AB,
Page 12.
yes.
Dedication of this present petitioner has performed the marriage of 14 years back. This is the allegation. And he also performed other marriages. This is the allegation.
Who is he?
He is a cultivator, he is neither Kazi nor Mullah or anything else. Now you have page 12, your worship, then you have kindly see, madam, the father of the God, page 19, madam,
Page 19,
page 19.
yes.
I have Boravadi Studio of India, that my daughter name is Ajina Khatun, date of birth so-and-so, who is reading at so-and-so school in class 9, and she is running student of the school. One culprit, Khadijul Rahman, he is a BDP secretary, nothing to do with secretary, madam. He is registered, case number so-and-so, regarding the marriage of my daughter of Ajina Khatun, aged 14 years with Mr. Akkar, aged so-and-so. is totally false and concocted story of the culprit, as that my daughter did not perform any marriage with anyone. And she is unmarried running student of class 9 and the person named Asmat Munshi. Never performed marriage of my daughter at Kadi so and so forth. Then Asmat Munshi already deep to him. LTI. But next page 21. He was saying, but I am a cultivator, I have no knowledge, I have never performed the marriage. Then it's to page 23, man. Headmaster certificate. He's student of the school. She's reading in the class 9. Then how these sections counts, my
So studying in class 9, does it prevent her from getting married?
I am not. Others say, my lord, not married. Person said, I am a cultivator, my lord, I am not either culti, I am not performing married. Headmaster is saying she is married. No, my lord, 70 years old this person. Unless I because the person might have his name is below.
Is what do you find in the CD?
My lord,
Why was it rejected earlier? Why was it rejected?
Earlier, my lord, just so you must kindly see, only because age, my lord. You have page 18 is the idea for a minor. Page 9.
No.
On the rules of the case diary reflects that your worship.
Hmm.
Page 81. The rules of the case diary reflect that there is no specific date of marriage for victim women, and as such, taking into consideration of the date of her marriage on 31st 12/20, the age of the victim women appears to be below 18 years. That is, at the time of her marriage, she was 14 years 8 months. For careful consideration of
What happened to this? Oh, this was the initial, there was a bail.
the initial page
Interim bail, okay.
page 1, he appears.
Hmm.
So there is no matter, no question of marriage, there is a girl's minor that is, father is saying my daughter has not been married. I am saying I am neither Kadi nor Mullah, and I am minor LTI, 70 years old, I am cultivated. The question of my sovereign marriage does not come here.
Resident of same place.
Yes, same. And a BTP secretary filed the case. And date is not given, nothing is there, a simple case was given, it is back statement. Now, custodial interrogation is required when I am only that is 70 years old.
When he says statement, he is conducted the marriage.
Yes, made that 161 he is taken. Two statement. Literally.
He says, my friend is saying that they have gone to the police station, they have written their own mind. Subsequently, they came to know that this is the
His statement, this is pursuant to the bail order, interim order.
internal.
Then
But whether the girl's statement or anything, very, because marriage there on my if there is marriage, of course, there is question that come. If there is the marriage, the question of solemnization comes.
no statement of the victim girl.
No,
Yeah.
I will put that.
no. Agreement statement, that time, as much as case it was possible to file the case at point of time that initiated. I don't know, 70-year-old grandmother comes to the interaction of the brutal cop murder, the time. Whether his matter custody will take any.
I think we call for a little updated CD, find out. This is about,
At least statement of victim.
all this will be necessary.
This is after amendment. Even
You are 70-year-old man, what will they do?
now I am.
So when can you get it?
2 weeks, my. That case, your worship may consider my. Keeping in view of his final age.
Heard Mr. H.R. Chaudhary, senior counsel, assisted by Mr.
Age Ali.
H. Ali for the petitioner. Mr. B.B. Gogoi and DPP for the state. This heavy petition is filed. This is the second levy petition filed by the petitioner, praying for anticipatory bail as he apprehends arrest in connection with Golabgonj PS case number 43 of 2023 under section so and so and so. Under the of prohibition of child marriage Act 2006 read with so and so and so. Full stop. Learned counsel for the petitioner. Submits that the petitioner is a 70-year-old man and cultivator by profession. The allegations made in the FIR are totally false and is in no way connected with the offences alleged. It is therefore submitted that the prayer for anticipatory bail be granted by the petitioner. Full stop. Learned APP has produced the case diary. Full stop. It is however submitted that updated CP will be necessary in this case, and accordingly prays for a short date or for updated CP. Let the matter be listed again on when can we get it? 27 June? 27 June, enabling the learned APP to call for the updated CD. Along with the statement of the victim girl, if available, also. In the meantime, if the petitioner is arrested in connection with so and so case, he shall be released on interim. You're right, like this, since this court in the earlier occasion had granted an interim bail. Full stop, comma. This court feels that similar interim protection can be granted to the petitioner. In the meantime, accordingly, in the event of his arrest in connection with so and so case, it will be released on the bail bond upon furnishing a bail bond of rupees 50,000 with one solvent surety of like amount to the satisfaction of the arresting authority. Petitioner will appear before the IO within 10 days from today and on such other dates as necessary, and he shall not directly or indirectly make any inducement, threat or promise. You shall not obstruct smooth progress of the trial, and you shall not move out of the jurisdiction of the Golabgonj PS without written permission of the IO. List accordingly again on 27 June. Proceed.
27/6.
27/6.
Statement, 164 state will also, that will also help us.
We don't know if it is there. We cannot compel.
Daily list for orders, I think 35 and 36.
Yes. Why is it listed for orders?
No, we have issued a notice against the respondent number 2 in this case. And the respondent number 2 has been received as part of the.
As per office note dated 28/3/2023. Service on respondent number 3. Respondent number 2 is completed, however, manifests on behalf of respondent number 2. Who is the respondent 2?
No, he is the informant of this case.
The informant.
Yes.
What is this matter?
Not,
POCSO.
not POCSO. Under section 366 and 34 IPC.
And
Informant is the father or mother?
Yes.
Huh?
Yes.
Father.
Yes.
Since the matter is admitted for hearing, let by earlier order dated 16/2/2023, let the matter be listed for hearing. Yes.
37.
Yes, Mr. Sinha.
Minus. Minus.
Await service reports on respondent number 2 and 3 as per office note dated 23. Oh, you are appearing. Office note dated 23/5/2023 reflects service report on respondent 2 and 3 is awaited. Also, however, Mr. A.K. Azad appears before this court on behalf of respondent 2 and 3. Mr. B.P. Sinha appears for the petitioner. The list for admission.
Yes.
You want to file any objections? Learned counsel appearing for the respondent 2 and 3 seeks liberty to file objection. Matter be listed after 3 weeks for admission.
Supplementary list for orders item 55.
This IA has been filed for settling the bail lordship which was granted the accused respondent number 1 lordship by order dated 19/4/2015. The order is at page 33 lordship. From the order, it says after appraisal of the case diary, there was no injury report was found and lordship has granted the bail. That's pretty right. Lordship, and after approving the bail, the respondent number 1 accused filed the terms of bail condition lordship. Yes, taken. I have subsequently lodged an affair lordship at page 38 lordship. Page 38. The type copy I have missed 2 lines. That is why I am showing lordship the condition. Page 38. This is all DDLG was made at page 39. The group of the height number 12 dated 34/2023.
30.
DDLG lordship page 39. The last part lordship in left. Bottom lordship. The group
Yamaru Kothar.
height number 620 dated 34/20. On midnight 29 lordship, he second lordship that I have appeared in the act, submitted the chapter lordship, that duly received lordship. No, today the first. Lordship, kindly see the nature of injury lordship, and subsequently page 40 lordship, this is an allegation against the police station lordship. I filed a complaint with the honorable DGP also lordship, including my subsequent affair lordship.
You have filed, this is an FIR.
That's the case that 38 lordship, subsequent affair. After granting of the bail lordship, the second lordship,
You have filed an FIR again.
again lordship. The lordship, kindly see the injury lordship, and I am to take a lordship attention. Kindly see page 23. Page 23 is the medical certificate lordship. The incident took place on 18 February 2023. And he was badly injured, like he was staged. This had 20, date of admission lordship with Thailand lordship get it 18/2/2023 and date of discharge 11/3/2023. He was there in the hospital 22 days lordship, including 4 days ICU lordship. Next day lordship will find the injury lordship. He was attacked with in the after some latent item lordship like rod or something like this. 24 lordship, kindly see the photograph lordship. Then lordship 25, these are the photographs. So in page 27, along with his mother lordship, he was in the hospital. And lordship, I have to take a lordship, page 29. This is a medical certificate. I don't know what kind of certificate was produced before this court to showing that he has got the normal injury lordship.
You get a copy of the bail petition. This is the bail petition.
Yes, lordship.
The certificate, the medical report will be here only.
No, lordship, after appraisal of the case diary, lordship, it is not there.
Oh,
It is not there, lordship. Lordship, kindly for a moment, lordship, I am to take a lordship, page 29. Page 29 is a certificate, lordship, what kind of injury he has got, lordship. Page 29 is an IA, lordship.
1 minute. Yes,
The dated 20 February 2023, immediately after the 2 days, the skin was very thin was that. This marked an extra ecmeral peristaltic shaped blood density. Residual with perilesional edema is noted along left frontotemporal convexity with a maximum depth of 0.4. And these are the lordship. I don't know the medical terms, but as he said, here the petitioner lordship, the victim is he himself a doctor lordship. He is serving rural lordship. And lordship, last line, suspected fracture is noted in squamous part of the left temporal bones lordship. Lordship, these are chronologically base 30, these are the.
what is your medical status now?
Now lordship, he's almost okay. After that, he also went to the Kokilavin hospital, there was a surgery was done lordship. They will find lordship. You will find lordship page 31, type copy, and 32 is the certificate from Kokilavin Dhirubhai Ambani Hospital.
What surgery?
And lordship, lordship in 32 I had it is somehow I got an instruction to the patient and urgent care advice lordship. The last part lordship. In case of surgery related bleeding, swelling, pain, or fever reports to AE immediately.
That is an advice. What surgery was undertaken?
Lordship, sir, he unable to talk properly. Lordship, he got some pain inside his leg. Lordship.
So far, 32 is concerned, this is regarding cyst, it's not an injury.
Maybe lordship, but this is the report and substitute lordship.
No.
It's 32.
Injury, the surgery related, surgery and emanating or required to be undergone because of the assault
Yes, lordship.
is a different issue.
Yes, sir.
Is different from surgery you have undergone because of some other issue.
Lordship, from this.
How do you say that? How do you say that? You get the reports,
Yes, lordship.
you get the complete medical reports, produce it before the court.
At least I am paying the notice may go lordship.
No, notice will issue provided you show us that you are required to undergo such treatment.
Might have there, but might have just that, but I.
No, not might have, it is bound to be there, it's a famous hospital, it's bound to have it in their record.
Actually, it is there, lordship, and they.
You get it by way of an additional affidavit will
Yes,
issue.
sir.
Is the kind of tumor only, is it?
Not this, not this.
We don't know, I'm not a medical professional, so I should not presume or assume anything. Yes, heard Mr.
Yes, ma'am.
S.U. Ahmed, learned counsel for the petitioner. This IA has been filed seeking cancellation of the bail granted by this court by the order dated. Where is the order? 19/4/2023 passed in AV 683 of 2023.
Very clear.
Also, by the state AV petition, by the state order, the bail petition, AV petition filed by the petitioner therein, namely Sri so and so, who is arrayed as opposite party number 1, was granted anticipatory bail. So, learned counsel for the petitioner submits that pursuant to the grant of anticipatory bail, he has violated the conditions mentioned in the said order and has threatened the present applicant, who was the informant. Also, the applicant has accordingly lodged an FIR before the Gavaru Pathar PS case, PS Dibrugarh by the FIR dated 3004 before the Gavaru Pathar PS Dibrugarh. Full stop. It is further submitted by the learned counsel for the applicant that the injuries suffered by the petitioner because of the assault was by the opposite party number 2, were grievous in nature, and in that view of the matter, the applicant and the opposite party number 2 ought not to have been granted the anticipatory bail. The learned counsel for the petitioner applicant submits that in that view of the matter, the application present IA has been filed seeking cancellation of the bail granted. Mr. R. Kaushik Lanak, ABP, appears for the state, who is arraigned as opposite party number 2. Let notice be issued, returnable after 4 weeks. Meanwhile, steps on respondent number OP number 1 by registered post 80. Since Mr. Kaushik appears for the respondent number 2, OP number 2, no fresh notices are necessary. However, extra copies be issued, furnished within a period of 1 week from the payment. List accordingly. Yep, madam.
For hearing items 38 and 39.
It's a lordship. For hearing for the petition on behalf of my senior Mr. Kumar, your lordship, learned senior counsel, Mr. Ken Chaudhary, has been heard by your lordship at length for the petitioner. On the last occasion, your lordship, the respondent NRL had sought for time to produce a report and they were to argue the matter with you. Lordship, the records are there, but Mr. Nair is not well. He expressed left some time ago. We pay for a slight accommodation together.
It is a partner matter, that's the whole difficulty.
Lordship, may I pick it up anything next week, Lordship? Lordship, may I pick it up on Tuesday, also, Lordship?
Let us have it on 6th.
Next of June, Lordship.
6th of June,
Lordship.
at the request of MS Anita E. Verma, Learned Counsel appearing on behalf of NRL. Matter is deferred till 6th of June. Your name, please?
See that.
C. Das appears for the petitioner. Mr. A. Shandillo appears for the petitioner in the second matter. Noted. List on 6th.
Item number 40.
I'm put a respondent number 1.
Hmm.
This is under section 138 of the negotiable instrument act. The petitioner is convicted under section 138 of negotiable instrument act. By the trial court, Lanak judicial magistrate first class, Kamrut Metro Act 1.
Where is the order?
Order. The parting part of the order is paid 27, 20, 28.
Yes,
Upon hearing the case merit,
yes.
upon hearing the accused considering the nature of the offense,
No, you read from 26. 26 or 27, 25.
25. In view of the above discussion, it is held that all the ingredients of the offense under section 138 of negotiable instrument act 18.
Oh, wait. First, take us to the points for determination. Where are they?
Point to determination is case 20.
20. Yes,
Para 7.
yes,
Merit.
yes.
In order to arrive at a definite conclusion regarding the matter in dispute between the parties, upon perusal of the case record and upon hearing both sides, I have found the following points for determination. 1. Whether the accused issued a check bearing number certain such dated 31/5/2013 for an amount of rupees 8,25,000 in favor of the complainant for the discharge of any legally enforceable debt
debtor liabilities. Para 2, whether the check was dishonored for insufficient funds in the account of the accused at a relevant time of presentation of the same in bank. Para 3, whether the accused received the demand notice issued by the complainant regarding dishonor of the check. Para 4, whether the accused has failed to repay the check amount to the complainant within the stipulated period and thereby committed the offense punishable under section 138 of Negotiable Instrument Act 1881.
Yes. So far as so what were the findings?
Findings,
The first was point number 3.
point number 3. Whether the notice, demand notice
So it was held to be received.
received by duly received by the accused person. The complainant PW1 has contended that he has sent demand notice on 10/6/2013 to the accused pro register post with AD demanding
no.
payment of the
Okay,
amount.
then number 1,
Number 1 is
for discharge of legally enforceable liability.
yes. Page 22.
Yes.
Para 12. The complainant as PW1 in his examination and sheet reiterated all the facts pleaded by him in the complaint petition, as well as of his initial deposition. According to PW1, he has provided a financial assistance of rupees 9 lakhs to the accused due to financial constraints faced by the accused, on condition that the accused will repay the amount within 6 months. However, according to the PW1, the accused has only repaid an amount of rupees 75,000 on case to him on 31/5/2013. And therefore, in order to discharge his liability for the remaining amount, he should take in question in his favor for an amount of rupees 8,25,000, which got bound when same was presented for enforcement. On the other hand, the defense witness in his evidence deposed that he has neither taken any financial assistance from the complainant nor has issued any check in favor of the complainant. Rather, the accused as DW1 contended that the check in question was a check lost by him, for which he has already lodged FIR before Kolkata Police Station on 14/6/2013.
Yes, can you?
Now, let us analyze the materials before court, keeping in view the plea of both the parties. From the materials available before court, it appears that in order to substantiate his plea, the PW1 has produced before court the sake of it, sake as Exhibit 1. Evidences of defense show that the defense never denied the signature in the sake as his signature. The accused as DW1 only contended that he used to give blank check by putting his signature only to his manager, and his manager used to issue such check to whom same are due. DW1 deposed that few of his check, including the Exhibit 1, were lost by him, for which he has also lost before police an FIR on 14/6/2013. The copy of the FIR has been produced before court as Exhibit A, whereas during his statement under Section 313 of CRPC, the accused alleged that a complainant was a tenant under him and Exhibit 1 check was stolen by the complainant from his house. Carefully analysis the copy of FIR said to be lodged by the accused. It appears that in the FIR it has been alleged that accused has lost the check. He never alleged any commission of theft of check from custody of the manager of his business. Whereas he contended that he used to give blank check to his manager by putting only his signature. The accused, on the other hand, never denied that other handwritings in the Exhibit 1, which state amount of money to be his. Though the accused contended that Exhibit 1 blank check was stolen by accused, but he failed to prove it that other particulars in Exhibit 1 were not his handwriting. Even from the Exhibit A, it appears that in the FIR, the accused himself as informant had put a cut mark over the word stolen in the subject matter of the FIR, meaning thereby that he never believed that check including Exhibit 1 were stolen.
The accused also failed to call his manager as witness to prove the fact that he used to keep client check in the custody of manager. And from there, same has either been stolen or lost. Again, it appeared from record that accused had lost the FIR on 14/6/2013 regarding loss of a number of checks and a certain personal document. Whereas the complainant has claimed that demand notice informing the accused regarding bouncing of the check with a demand to make payment has been sent on 10/6/2013. And it is claimed that same is also delivered on same day. Even if it is not believed that notice was served on 10/6/2013, as per settled position of law, it can very well be presumed that same was served prior to 14/6/2013. Thus, to me, it appears that there is scope to apprehend that after receipt of the demand notice, the accused, in order to save himself from being prosecuted or to get himself absolved from his liability of repayment, has lost the FIR. Such apprehension is backed by the very fact that whereas the accused very specifically in his FIR mentioned the number of checks said to be lost by him, but he never stated in his FIR what personal documents he has lost. There is reason to think that he emphasized only on the check so as to create a story regarding loss of the check and hence ignored regarding the documents he lost. It appears further that while filing the FIR, the accused was himself confused whether he has to state whether the check has been lost or stolen, for which he put a cut mark over the word stolen. He even failed to state in the FIR when he lost the check. Again, admittedly, the accused had never made any direction to stop payment from his account after loss of the check. In this regard, I am of the considered opinion that when the accused who has very knowledge as to loss of check, whereas he alleged to have habit of keeping check with only his signature without inserting an amount, he first of all ought to have made direction for stop payment regarding such check. On the other hand, there is reason to believe that the accused could not have made stop payment because of the fact that he has developed the story of loss of check only after receiving notice from the complainant as to dishonor of the check, and at that point of time, he has no portion left to make stop payment. Moreover, the accused also failed to prove the fact as to lodging the FIR by him by calling witness from appropriate authority.
Yes, then
Recorded further transpires that the defense failed to state the credibility of the complainant PW1 regarding granting of financial assistance to him by the complainant. PW1 during cross-examination also remains firm with his statement made in the examination and sheet and in categorically terms contended that he gave ₹9 lakhs to the accused. On the other hand, defense made him admit that he has not issued any money receipt when an amount of ₹75,000 was repaid by the accused. Meaning thereby that as contended by the complainant, the fact that out of ₹9 lakhs, only ₹75,000 on case was paid by the accused, it is a true fact. Neither the accused denied that he has contacted by the complainant personally and requested him to settle the debt after bouncing of the check, but before issuing the demand notice. Regarding the matter in issue, I would like to flash reliance upon the following Honorable Supreme Court. Lordship, the petitioner has often filed an appeal before the learned session. The session appeal the order passed by the learned trial court. After they filed this revision petition before the court.
yes,
Lordship, the petitioner and the accused person took ₹9 lakhs from the accused from the complainant as a loan. Thereafter, he returned 75,000 and issued a check of ₹8,50,000, 8,25,000 for discharge his liabilities.
who appears for the petitioner? Who appeared for the petitioner? Earlier?
Mostly so that
Just A. Kusami and P.N. Das.
You give your citations, whatever you want to rely, some judgments you are relying on.
Okay.
Are you relying on any judgments?
Lordship, I'm feeling their point is only that notice is not duly served, Lordship. Their only point is that notice not duly served. And
On the petitioner before the trial court?
yes, Lordship. No, their main ground, petitioner main ground, the accused person main ground is that he has not received the demand notice.
Ah,
But during cross examination, the accused person stated that his address and the notice sent to the demand, the address which is mentioned in the demand notice is the same address. That's great. Kindly page 34, the appellate court.
one minute.
Para 11, on perusal of activity 1, page 34.
Yes, para
Para 34.
of page.
Page 34, para 11. The appellate court.
Hmm.
On perusal, the second question, it appears that the same was issued on 31/5/2013, and on the same date it was presented in the bank for encashment. Bank returned the check with return memo on 4/6/2013, and the complainant issued demand notice to the accused 10/6/2013. The accused filed the FIR on 14/6/2013. The date of filing of FIR is very crucial. Exhibit 5, the postal receipt, shows that it was posted on 10/6/2013, and within Guwahati, the postal department can deliver the same within 2 or 3 days. The accused appellant in his deposition has denied receipt of the demand notice. The accused in his cross examination has given his postal address, and on perusal the address mentioned in the demand notice, it appears that the notice was issued to the accused at his correct address. As the notice was sent to correct address, so it can easily be presumed that the notice was delivered in time. Perhaps the accused filed the FIR after receiving the demand notice, thus to take plea that the check was stolen. From his evidence in sheet, it appears that he handed over the signed check book to his manager so that he can disburse the same to the person whom payment is required to be made. If that is so, the manager ought to have been best person to disclose under what circumstances the check leaves were lost. But the accused had not examined his manager. Even his name has also not been disclosed by the accused. In Exhibit A, the accused has not disclosed the leaves of the check book had been lost from the hands of his manager. The accused has not mentioned in Exhibit A when he came to know about the loss of his check leaf. The story of the losing of the leaves of the check book is nothing but after.
We are just posting it for one more day to see if anybody appears, otherwise we will close the hearing. List on Leonard, what is your name, please? Lee Chutia, Leonard Lee Chutia appears for the respondent. However, none appears for the petitioner on hold. On earlier occasions, on 4/6/2020, when the matter was called, none had appeared for the petitioner. None had appears for the parties. Considering the fact that this is a matter of 2017, the court proceeded to hear the matter. Mr. Lee Chutia, counsel for the respondent, has been heard. Matter is kept for further hearing on 6th of June.
Okay, before 6 or after 6, any date.
Before 6th or after 6th, 8th of June. Enabling the counsel for the petitioner to address the court. List on 8th. यार एक डिपोजिशन मिले देखना चाहिए सबसे और की है ये बाटी लोग एक बार हेडफोन में भेजे तो 48 है
Item 41.
Before starting the case by other side, my lord, I had to submit my lord. In this case, I verified the record. The respondent number 2 service has been found in the short signature. It is a case of maintenance, my lord. And the wife was unattended before this honorable court.
You are appearing for whom?
I am appearing for the state, my lord, respondent number 1. And it is a case from Arunachal Pradesh, she is from Arunachal Pradesh. The financial condition may not allow her to appear before here also, my lord.
Why is it filed here?
So, my lord.
Seeking transfer.
Yes, my lord.
You know, notice has been issued from this honorable court. And lastly, you know,
No, what you're seeking transfer
yes, you know,
from
from UPI, Arunachal Pradesh petition with the first class to sub-division judicial magistrate Margherita.
why?
But the continuous trip from the in appearing there in before the
What is the matter about maintenance?
maintenance, because on other two ground is already the garden property and
Is there any divorce proceedings going on?
no, restitution case is already going on.
What is going on?
Restitution case is.
Restitution, okay.
Before the,
Filed by the respondent,
we, the petitioner.
filed by the petitioner.
My lord. And the custody case is also going on, and
Hmm.
there they have appeared. My lord.
One thing is that,
And
my lord,
those cases are now at the stage of argument, what I got the information. My lord.
one thing is that, my lord, there is a maintenance order for payment of.
See, there is treat me not, so we, my lord, through SP, we have.
Matter is pending where in
In UPI,
UPI.
my lord.
It should have been filed before the eternal bench.
Yes, my lord.
And we communicated to the SP also, and this has been intimated to the honorable court also. And then last occasion, the honorable court sought from the PT, what is the status of that case? Whether
When was it filed? 2018.
18, my lord.
Should have been filed there. Since there is already a bench.
It was allowed, my lord, there with the permission. At that time, it was not there. That should be-
Because we do not know the financial condition or other aspect of the child, my lord. Normally, the law of the land where white has been, my lord, decided, case will be, my lord, running on that particular place. We are the formal party, my lord, respondent number 2 is not available, my lord. And whether she pays the maintenance or not, we
Now,
do not know.
the two cases is already going on in the market.
There is an order, my lord, there is no stay order. for matter, whether he paid or not, I don't know.
Have you paid?
And we not, since we are unable to appear here, and we issue the notice to provide the account also. But no account, then in the meantime, we have through money order, we have sent, but no communication from their side. Now, but they have appeared in the market, and they have filed their WSWO in both the cases.
Maybe they are not even aware that you have filed the case here.
They
You
have,
take fresh steps. And you take steps by Dusty.
that's the.
Because you are appearing in Margarita.
Market, no problem.
You are appearing, you serve them. Take fresh steps by Dusty. Mr. S. Sharma, learned counsel for the petitioner, submits that this that the notices have been served on the respondent number 2. Mr. NNB Chaudhary, learned additional AG, appearing for the state of Arunachal Pradesh, submits that as per office note, as per the endorsement made on the postal receipt. You are referring to the postal receipt.
Yes, sir, in order, there is a short signature is there.
Where?
I have found one.
In the postal receipt.
Yes, sir. Short signature.
It is not discernible whether proper signature of the respondent number 2 has been obtained or not. It is, he submits furthermore that the respondent number 2 is a resident of the state of Arunachal Pradesh. And there is already a permanent bench available before the Arunachal Pradesh, and therefore matter, it will be convenient for the respondent number 2, being a lady and the wife of the petitioner, that the matter should proceed before the Arunachal Pradesh, before the permanent bench of Arunachal Pradesh at Itanagar, at Nahalon, Coastal. Considering the submissions made by the learned counsels for the parties, this court is of the view that the learned additional AG is at liberty to file necessary applications before the registry or taking appropriate steps, if so advised. Meanwhile, the petitioner will take fresh steps on the respondent number 2. Dusty is also permitted. Let the matter be listed again after 4 weeks, enabling the learned counsel to the petitioner to take fresh steps by Dusty. Fresh steps.
In Margarita, because so far I got the information for last 2 occasions, they have not appeared in those cases also. In Arunachal, it will be difficult from us to start that.
No,
Because there is a threat from their side, and we have communicated.
no, you said they are appearing in Margarita.
Margarita, last 2.
So you take Dusty. We are not saying you take Dusty in Arunachal. We are saying you take Dusty. If they're available in Guwahati, take Dusty in Guwahati. Dusty is to just serve them personally, wherever they're available. A list after 4 weeks.
Item 42,
Yes.
If application is to pass an FIR with the registered at school police station. All people will be going into, I checked the records below. These records are of this police station are not available. Records of another police station is available. Though that record is necessary for adjudication of the matter, but as well as the records of this school police station will also be required.
Why?
Statement, provisional of 161 statement.
We can call for it,
Yes.
Mr. Gogoi.
Lordship, he is selling the second FI, it is the sameness. But FI is defined contention law.
Dispute is the second affair.
Yes, Lord.
Records of dispute are not available.
Respondent have filed three FI, Lordship. One is Panbazar and one is BIO and one is dispute police station.
Hmm.
He had challenged the second FI dispute police station and he got a interim order, Lordship.
Hmm. What happened to the other FIRs?
Other FI, Lordship, I have filed annexa I, Lordship.
Other FIR that's resulting in toxic mallet, we challenge this.
One more police station, Lordship.
We challenge this circuit that is pending.
Civil just have required a SFL report, Lordship.
CIO case is taken after the field. That may be.
BI is case is sitting and misappropriate of the respondent money, Lordship. Second FI is filed, Lordship. It is another contradiction, Lordship. Dispute police station, Lordship. Those who have been fraudulently signed, filed suit on behalf of my respondent, Lordship. Signature.
The result of 161 statement will be ready.
There is no specific allegation against the.
You're challenging this on what grounds?
Well, apparently it is a second affair as well.
Then- No, second affair, you will have to urge that.
Yes, yes, both are affairs are annexed manner, so we can see the similarities. Apart from that manner, it is completely a civil nature, it leads to an apartment manner position, the petitioner manner, he is.
Why have you filed so many affairs? One after the other?
Lordship, one is Lordship FIR, BIO is Lordship sitting and misappropriate of the petitioner to without deliver the flat Lordship.
Hmm.
Second FIR is filed Lordship.
Who is the respondent? Who is the petitioner? Is the builder?
He is the petitioner.
He is the builder.
Builder Lordship.
Ah.
Second FIR, they have no specific allegation against him Lordship. But they have no Lucas Stanley to file the instant case Lordship. That is a very interesting.
Where is this FIR? In the-
FIR Lordship 100, Lordship 13 Lordship case.
Yes.
Mayor property question 150 Lordship.
Hmm.
Mayor Lordship.
Yes.
Your Honor, I beg to state as follow. I have perfected flat in.
This is the BIO.
No,
CM Vigilance.
This is under change.
Second FIR filed by this Lord.
No, he is challenging which FIR? This FIR, 115.
115 is the second FIR.
This is under challenge.
Yes.
Yes.
You have got interim order.
Yes, please read.
I have purchased a flat in Guwahati, Assam, costing 6 lakhs, means from Ajmer plus 10 lakhs, arranged by me. After executing sale deed on 31/2006, I got possession. Also accordingly, I got municipality holding number, ACB connection. Number 2, further I was transferred from Assam ONGC, Mehsana, Gujarat in the same year. My brother started to live in my flat. He also transferred from Guwahati to Dibrugarh in September 2008. On 9/1/2009, in absence of me and my brother, an unknown person to me named Dilip Pal broke the lock and entered into my flat. And with criminal intention, he stole all my furniture, household goods, heating, electronic items, etc. of cost about 20 lakhs. The safe number 4, the safe property is mortgage property to SBI till loan amount is clear. According to loan agreement since September 2006, I have been paying monthly EMI 6,360 rupees till date, and it is to be continued till the year 2021. On the other hand, Dilip Pal is earning money by keeping tenant in my house. In this regard, I informed SBI official P245, but instead of proceeding for legal inquiry and action, they pressure me to continue EMI. So I feel enormously harassed and mentally disturbed due to this strain on my finance. As a nurse, BSc,
and PG in Hospital Administration and Management Technico. My ethic is to serve the ill, weak, and needy people. I am a share obliged mother of 3 children and also liable to my parents. As an employee of ONGC, every month we are paying to PM, relief fund, tax to God, and also to other relief agency, society, and organization as and when necessary. I purchased a house in my native place with much difficulty with my earning of full service life. 6. The accused could only be detected when I personally interact with them, some police advocate in some situation, and it finally became clear when I study after collection of my 2 copies of case from the copying section of Guwahati High Court on 19/2017. The 7th detail has been stated as below. If the builder has to return money 3,50,000 to Dilip Pal, if yes, then the process of giving to and return back the money from was between these 2 persons only. That was none of my business from any point of view. I was not concerned with their problem. The culprit Dilip, with the help of some gov and non-gov personnel, prepared some fraud document, and thus he criminally trespassed into my home and solved his problem. In the incident, this stanza deprived me of my civil right. For deed of agreement, the cost of stamp paper used was only 5 + 1 = 6. Below 50, the stamp paper is invalid. Only 1 person had signed for seller, purchaser, and advocate, witness, builder, SM Dustidar, who signed in my document, does not have his sign in this document. Dilip himself even not signed. So how did Dilip Pal falsely claim that he flat purchased by me was the same one that he purchased from the same builder? This is a blunt criminal act of forgery. So it should enter. The conspiracy of criminal intention. This scheme as a Dilip Pal has been acting as a both me and the builder till now. When one of basis of fact deed of the agreement and decree order passed on dated 16/6/2017, this culprit did not find a flat in the ground. Then after 3 months, he with his advocate Anupam Sharma, Krishna Nath, Vishwadip Bora, and notary Pranab Talukdar filed Miss Case 120 on 3/10/2007 and 23/24/18 signed in my name and submitted in the High Court. Further, in my absence, whom did they show as a Bhanu Rashtra, and how did they state that I was residing in the flat with my family for those years? There is no ONGC medical record in Guwahati, and my service record proved that I was living in Mehsana, Gujarat from June 2016 to November 2009, and thereafter at Ahmedabad, though this case does he found a way to grab my property. Thus, Dilip Pal, with the help of some advocate, has stated about managed to get a vacation order, brought the police to.
Who's the petitioner here?
He's the builder.
There's some problem. I don't think I'll be able to take up this matter.
Lordship.
I did not see the name of the petitioner.
Simple question is that, Lordship. Criminal, there is no specific allegation against the criminal petitioner, but he had filed a instant application, Lordship. And he got interim order, Lordship. At this instance, your Lordship kindly vacate the interim order, give a direction to the this police station to
No, I can't.
action.
I should not take up this matter
Lordship,
before any other bench without me.
Lordship.
Then 43.
Sorry, I did not see the name of the petitioner. Otherwise, I would have not taken it.
May I please, Your Lordship, my lord. There are several witnesses in this case, my lord.
Where?
I may not be permitted.
Huh?
Today, may not permitted.
You may not. I'm sorry, I didn't get you.
The date may kindly be fixed. As per convenience of the honorable court, make it 15 June, my.
It is the track matter.
Yes. That matter, that collected.
Track from Guwahati to Tezpur and then to
Yes,
Rajasthan.
yes, that is the case. Interesting case.
Very interesting, yes, yes. All right, at the request of Mr. learned counsel for the petitioner. Let the matter be listed on 15 June.
No, 15.
Mr. SCKL appears for the NDPS.
Much.
44.
Here I'm challenging an order passed by the learned passenger at Warrior. An appeal filed under section 49C of the Assam Forest Regulation Act. The appeal was dismissed and my vehicle has been confiscated. The basic fact of the case is that I was carrying some timber. I was bound with some timber along with my vehicle. But those timbers I did not procure from the any forest area. Those timbers we used for construction of village, bridge in a village. So after the completion of the bridge, the residuary
Where do you get timbers otherwise than from the forest?
I purchased this from a third party. And I don't know from where he procured. But so far as my vehicle is concerned, it is my only source of livelihood, and I have purchased it paying EMI, monthly installment. So the appeal order you will also be filed at page 31.
Confiscation of the vehicle also,
Vehicle also,
as well as the other goods.
other goods.
Yes, Forest, why do you want to keep the vehicle?
Otherwise, your lordship, duty has been cast upon us by the Honorable Supreme Court, even when vessels, vehicles, when block carts, if they are used for commission of forest offences, it is preferable that they are confiscated, your lordship, so the forest offences are not perpetrated. So, but
What's the judgment?
yes, but without going into that issue, your lordship, because on merits, there will be judgments to and fro. This appeal was filed under section 49C. If your lordship kindly has that forest regulation for
Forest regulation.
forest regulations of 1881. This might impact the petitioner's case, but it's very important to perhaps
Yes, 49,
49C, your lordship. Appeal number
49C. Yes, appeal.
appeal. Any person aggrieved by an order under section 49(4) or section 49(b) may within 30 days from the date of communication to him of such order prefer an appeal to the district judge having jurisdiction over the area in which the property has been seized, and the district judge shall, after giving a reasonable opportunity of being heard to the parties, pass such order either varying, confirming, modifying, annulling, or setting aside the order appealed against, and the order of the court so passed shall be final.
What is this? This is a judgment passed by the in appeal.
Yes, this is a judgment. If I may
Under
take your
49C only.
If I may just take your lordship to the order, which starts at page number 31, your lordship. Lordship, which has been passed by the Honorable Sessions Judge, not by the district judge.
Oh,
And there is a judgment of this Honorable Court, your lordship.
perhaps
So there is a judgment of this Honorable Court.
the same person exercising,
The same person, but he cannot.
but I don't know, yes.
Perhaps it will have to be remanded back to be decided afresh by the district judge.
Yes. Yes.
Paragraphs 4 and 5 here.
What do you say?
But learned district judge, the second judge is the same person who is holding the position of district judge too. And so far as the judgment is concerned of 2005, it's after 18 years we have come across this kind of situation.
But though here the jurisdiction is given to the district judge, but it's only the nomenclature, but the function of district judge, session judge and the authority would be same. And this forest offense is a criminal offense, it's not a civil offense.
So show us some authority. He says 49C,
That is-
power is reserved on the district judge. Now you have to say that district judge would mean district judge as well as the session judge. That is what you are saying.
Because to the per se, this district judge, Lorry district judge, session judge is empowered with the same authority, same power. The question is that whether he has got the jurisdiction or not. And if the question comes from jurisdiction, yes, in my humble submission, he has the jurisdiction. But the nomenclature says the district judge doesn't take away the jurisdiction from the session judge.
Show us some authority.
I'm sorry, so far as this aspect is concerned, from this honorable court, there is, or other court, there is no such authority. But so far as other jurisdiction is concerned, jurisdiction we divided by pecuniary jurisdiction and the territorial jurisdiction. And the
Criminal and
status,
civil jurisdiction as well.
yes, so,
No, there is a judgment of our court.
yes, 2005 judgment. I am
Yes,
aware about it.
yes. So,
After that, no such judgment has been passed. And since the nature of offense is criminal, so client tends to file an appeal before the session judge. They write before the district and session judge, but it is taken up by the session judge as a criminal appeal. Because these are the offenses criminal in nature, not civil in nature.
So there is another judgment of
Hmm.
the Honorable Supreme Court, which might throw some light on why the district judge has been specifically empowered. This was in relation to the Forest Act of 1927. Where all the perimeter provisions are there. Let me quickly take your lordship to paragraph number 43. Your Lordship.
yes.
A confiscation envisages a civil liability, whereas an order of forfeiture of the forest produce must be preceded by a judgment of confiscation. Although indisputably having regard to the phraseology used in subsection 2 of section 59 regarding that act, there cannot be any doubt whatsoever that commission of a forest offense is one of the requisite ingredients of passing an order of confiscation. But the question as to whether the order of acquittal has been passed on that ground and what weight should be attached thereto is a matter which in our opinion should not be gone into at this point. That is not relevant, but what the Honorable Supreme Court has said is that the confiscation envisages a civil liability.
Where in this judgment?
I'm reading, this is 2004, 4 SCC, volume 4 SCC 129.
Hmm.
I'm reading from paragraph number 43. Your Lord.
43.
Yes, sir.
Yes.
The first sentence of that paragraph.
Hmm.
The confiscation envisages a civil liability.
Hmm.
Whereas an order of forfeiture of forest produce must be preceded by a judgment of conviction. This is a case, your lordship, of confiscation. So that is why perhaps under the rules, likely the power has been granted specifically to district judge.
Hmm.
In that case, the Honorable Supreme Court was dealing with the question of, not the question of jurisdiction, who has the jurisdiction to try the offense. If I may take your honor, lordship, to section 49(5) of the regulation.
See, there is a judgment of this court. Now, ordinarily, it is binding. Now, if you want to distinguish, you have to distinguish on facts that this judgment is not applicable to the facts, or it was delivered by not taking
As of now,
the attending facts and circumstances. So you examine this judgment and come back again.
but I have examined, and unfortunately, there is no other judgments except this. I have lay my hands on. And if I may take your honor, lordship, for a moment to 49(5),
Hmm.
the confiscation proceeding, how it starts. 49(5) of the Assam Court Regulation 1991.
Yes.
No order confiscating any property shall be made under the preceding provisions unless the authorized officer sends an intimation in the prescribed form about the initiation of the proceeding or confiscation of property to the magistrate having jurisdiction to try the offence on account of which the seizure has been made. So the jurisdiction has been given to the magistrate, and here when a question of civil liability, the jurisdiction would have been given to the municipal court. So the magistrate has the jurisdiction to get the information whether any confiscation proceeding has been initiated or not. then the party will be given the chance before the magistrate. So the
Here what happened?
here, my lord, this confiscation proceeding, the order was passed by the DA, which is available at page 24.
Hmm. Yes.
Is in the court of authorized officer come divisional forest officer, Delhi division Noida, the order is 26/7/21. The history has been written in the order, and the final conclusion has come at page 28.
Yes.
The confiscation proceeding against the seizure has been finalized considering the confiscation aspect as independent and it is a separate and distinct proceeding or that of any offense. Therefore, the trial against the criminal aspect, this is the criminal aspect, will be continued in the Honorable Court of Chief Judicial Magistrate. Boyagaon against the seizure report submitted so and so and intimation communicated so and so. In this connection, it is further reiterated that it is proved that the forest offense committed by the accused involving the vehicle and hence in this respect the necessary supporting documents with respect to the confiscation proceeding enclosed to the Honorable Chief Judicial Magistrate Boyagaon as ready reference. The seized timber of 21 pieces measuring volume so and so, which are proved collected, transported without any authority involving the vehicle bearing number so and so, without any transit pass, are hereby confiscated to the state in the exercise of power conferred under section 49(4). The ICA Special Protection Squad Boyagaon in the custodian of the seized timber is directed to prepare a lot of immediate disposal on completed sale to avoid any deterioration of the forest punishment of like timber. So this intimation, the records are sent to the CGM Boyagaon and not to any of the civil authority. So from the entire aspect, in the aspect dealing here, we are dealing with the criminal aspect. So the appeal was filed before the district judge and the nomenclature says it's a district judge, but the order has been passed exercising the session judge. Be that
But you have been given the opportunity.
I have been given the opportunity. I am not denying that fact, but I am on the aspect of sending records, the intimation aspect. They are intimating probably to the magistrate and the CGM Boyagaon. They are not intimating or they are not producing a record before the Munship court. Had there been any embargo on the exercising of power before by the session judge, learned session judge, it would have been clearly stated here. And the records would have been sent to any of the.
No, but in the face of the judgment of our High Court, what is your submission?
I agree with the decision passed by the Honorable Court, but it's a passed by single bench. So your lordship going through the facts of the case may also vary from the finding recorded by the learned single judge.
We will vary provided you persuade us to vary. That is what I was asking you. That if you feel that the judgment is not applicable to the facts of the case, you have to argue like that. Ordinarily, it is binding unless you say the facts are different or the law has been not applied in a manner required to.
They also did not raise any objection before the learned court that this appeal is not maintainable because it lacks the jurisdiction. But they don't say that it is lacking the.
So why send it back? Why not interfere and finish it off?
That is what I'm saying, that this order as it stands now will have to be set aside because
We'll set aside.
we'll set aside the order and decide it and send it back to the district judge.
Why send it back?
Because your lordship, the district judge, your lordship. has-
We'll say that this is not an order in law. We set it aside.
Then if it is set aside, lordship, then we have no difficulty with set aside. But then the order of the DFO, that will come back into existence. That is all the challenging these positions.
That is for them to decide.
Yes, very well, your lordship may settle it.
That will create another difficulty for us because when we activate the petition as a learned second judge and the confiscation proceeding has already been completed, the vehicle will be
In fact, perhaps that would be the best course of action for them if this order is set aside and they file a fresh appeal before the district judge along with a copy of this order, so the jurisdiction is exercised in accordance with law.
But this order is a culmination of the order passed by the learned DFO.
Hmm.
So we challenge the order passed by the DFO also. While challenging the order passed in the criminal appeal. Only for the nomenclature, if this order is set aside without interfering with the other aspects, so it will cause prejudice to the client. Because they did not object it while the order was passed by the learned session judge. They did not raise any objection because the learned session judge is not empowered. They don't say. The only thing
Matter is, Mr. Swenzo, matter is heard at something. Is for a hearing on. Thirteen June. 13 June.
as part of.
I don't know, part or not. It comes. Yes. Where is your counterpart?
So no, just not alternative remedy. But in my reading, I specifically stated that there is no equally efficacious remedy.
That is the remedy. They're showing you.
Yes, no, I have in my pleading, I have already pleaded that there is no, I have preferred this petition because there is no equally efficacious remedy.
That's
Now-
right. Whether that appeal is or is not an efficacious remedy, have you stated in your petition?
Yes, Lordship.
Why? It's not petition.
Now, I have stated in my petition, Lordship.
How the appeal does not
Because initially no.
provide you an effective relief.
Yes.
How?
Lordship, at para 14, para 14, we have stated that we have no other equally efficacious remedy.
Hmm.
And in their affidavit,
They are silent about.
therefore they admit
No, those kind of arguments will not do. You have to urge, forget whatever you pleaded. If you want to urge, you urge. That this, although it is there, it is not an efficacious remedy.
It is not an application.
Why?
Lordship, because Lordship, lot of time has been passed, Lordship, and
There is a specific judgment of this court, recent judgment of 2022, wherein it's the same thing. Wherein no DP was conducted, only a preliminary inquiry.
Show us the judgment.
Yes.
yes, Lordship.
Yes. Lordship, this is the judgment.
Facts are
Give us the citation immediately.
Yes, the Lordship, I already have it. 2022 6 GLP 445. Here also, the facts is similar, preliminary inquiry was conducted, there was no DP. Thereafter, we challenged that there is no DP. Thereafter, the state took the same plea. That he has a remedy under section 50.
But I just very quickly. The facts are similar, only the preliminary inquiry. At page 4, Document 3, at 14 and 17, Lordship, two paragraphs I read quickly. It is no less intriguing that employees can have preliminary fact-finding inquiry, can proceed with expertise and have a report on it with an object of finding the real fact. The employer can also issue so-called charge on the basis of such material gathered through fact-finding inquiry. However, the same cannot replace a regular departmental inquiry
where the delinquent is not a part of such inquiry, nor the rules prescribed mandated of such inquiry are followed. 17. Now let the court deal with the argument of Mr. Sutia, learned counsel regarding alternative remedy. It is well settled that such principle and
We are not arguing, we are not asking you to urge whether alternative remedy is whether the writ, can we still exercise our jurisdiction in the face of alternative remedy? Not on that. We know it is a self-imposed restriction.
Yeah.
What we are saying is, prima facie, it appears that there is an efficacious remedy even under this statute. Why should you not be relegated? We are not saying it is an absolute bar. But you have to satisfy us that relegating you to the alternative remedy to hear on your grievances before the appellate authority, you have not given reasons why you have not gone before the appellate authority.
because Lordship, it is passed in violation of the statute itself. Lordship, it's an exception to the rule of alternative remedy. That is my point. Where I think Lordship, when it is done in violation of the principles of natural justice, because Lordship, I will show in the show cause, in this case, though there is show cause, there is no cause to give this punishment. Lordship will see the show cause. Show cause says that you will be punished under 1, 2, 3, 7, 1, 2, 3, whereas I have been given a punishment under 7, 7. Lordship will see page 30. Even there is no show cause, Lordship, I will just point out again. Moreover, there is a violation of a statute because section 15 of the college provincial rules specifically says that the departmental 1964 have to be applied. Page 30, Lordship, just read for one. So, in this case, there is no educated show cause also.
Okay, we'll continue if you want.
Yes, sir. Why
Tuesday,
any prescribed penalty?
we'll continue on Tuesday. There are some meetings I'll go.
Deeply obliged.
We'll continue on Tuesday.
11.
Any other orders to be passed? Say, leftover matters? Yes, well, dates you'll get. Is there any interim order to be extended, which is up to today? Okay.